Right, good morning everybody. The time is now 9:30 and the inquiry is resumed. For those that don't know me, my name is Helen Harkenhull and I'm a Chartered Town Planner. I've been appointed by the Secretary of State to hold this inquiry. The inquiry is into an appeal made by Lee Huff & Co under Section 78 of the Town and Country Planning Act 1990 against the refusal of outline planning permission by Chorley Borough Council for the erection of 123 dwellings land adjacent to Blainscough Hall, Blainscough Lane in Coppull. So before we start today, just the normal housekeeping matters. Mobile phones, can you please turn them off or on to silent? I'm going to assume that no one intends to record or film the event, and I'm sure there are no press present today, so that's fine. There is an attendance list circulating, or at least there should be. Can I ask all parties to sign that, please, before you leave today? I assume it's doing the rounds, is it?
It's doing the rounds, yeah.
Yeah, good, excellent. So I'll pick this up later. Can the council just remind us, is there a fire drill today or any fire evacuation procedures?
Fire is out the door, right, and right into the door.
Right, lovely, thank you very much. Before we start today, I just wanted two outstanding matters, I think. Mr. Ponter, have you anything to raise with me?
Nothing for me.
Okay, can I just ask on Tuesday, I think it was, do you recall, I asked for some information on the availability of sites. Mr. Wilson's evidence, Councillor Wilson's evidence looked at a limited number of sites available. Do you recall that? And you were going to get some information on the scale of that limited number of sites, if you recall.
Yes, that in the excitement of the inquiry, I think I've forgotten that. But Ms. Kurihara has noted it, so we'll make sure that before the inquiry closes, I give you that information.
Lovely, thank you. Yeah, it's fine later on today. It's fairly factual information anyway.
Yeah, absolutely.
Okay, that's no problem, thank you. Anything from you, Mr. Cannock? Right, okay, thank you. Well, I've just been handed a hard copy of the Section 106 agreement. I have already got that electronically, but it's helpful to have that in hard format. So today, our last day, what we need to do is, in effect, look at conditions and planning obligation and have closing submissions later on. But before we do that, today we have Sir Lindsay Hoyle here with us, who wishes to address the inquiry. So the first thing we're going to do, then I'm going to hand over to Sir Lindsay and ask him for his comments and observations, please.
Can I first of all take the time to thank you, Inspector, for allowing me to speak today. As you will appreciate, there are many competing demands on my diary, so I'm very grateful that I've still been allowed the time to contribute to this inquiry. So much so I came up from London, especially because I think it's important that I put my comments on the record, but also to support the local residents. So we come. Let's start. The safeguarded land, and that's what we're talking about, and the site at Coppull is designated safeguarded land within the local plan. The land was safeguarded to help meet the longer-term development needs stretching well beyond the plan period. It's my opinion that permission to build on this land should only be granted following an update to the plan in accordance with the National Planning Policy Framework. My grave fear is that we see less of the remaining safeguarded land, which leaves the greenbelt land exposed for future development as we run out of land available for development during the next plan period. The site in question was included as safeguarded land. I cannot see any justification for this site being brought forward for development now when it was designated as land which would not be developed within the current plan period. The 5-year land supply. Perhaps if we look at that, the main issue to be determined is the issue of an adequate 5-year land supply. From my understanding, we have 2 appeals in the central Lancashire area this year alone, one at Cardwell Farm and one at Chainhouse Lane. The former saw the inspector determine that the MOU-based policy of the core strategy provided on the basis of 5-year land supply. The latter appeal determined that the standard method should be adopted. In respect of this, I would like to make the following comments. The standard method is on a calculation which takes its base from the housing numbers delivered between 2009 and 2014. This period witnessed a significant amount of house building in Chorley, mainly due to development on the Buckshaw village. Indeed, over the past 10 years, Chorley has exceeded its expected housing numbers significantly. We built 1,567 houses more than was ever planned or envisaged. The logic of the standard method is, having built so many houses over the past 10 years, Chorley has now built even more. Meanwhile, Preston South Ribble, who've had a poor record of delivery, are rewarded with under the standard method by having a supply of lower number of houses. The standard method applied without some of the form of redistribution will simply lead to more and more development in one area. Unlimited development is simply not sustainable in the medium and long term. As you may be aware or not, I have met with Ministers, Secretary of State on numerous occasions, and they all acknowledge what a great authority Chorley is. We've always stood up, taken it on the chin, delivered what's ever been asked, and I think we've got the best record of delivery within the area, well, within the region. Now, let's really go for it and be honest, and let's put the case forward. Because what we had was a windfall site. We had a windfall site of Royal Ordnance. At that time, I was Deputy Leader of the Council, I'd been Chairman of Economic, and I had this vision of this great village, a sustainable village that was going to provide the future housing needs for Chorley. No, that was for the benefit of everybody around us. We brought that on stream. So we did the right thing. And quite rightly, we were building the houses that were required. But what we shouldn't be for doing the right thing is then be caned by giving us more houses later. Surely common sense should prevail at this stage to say other authorities should stand up and take some of that pain. And quite rightly, we understand it's painful for all of us. We're all committing NIMBYs, and that's very easy in life. I don't want us to be NIMBYs. I want to do the right thing by the people that we represent and the areas that we live in. So why should Chorley be punished for doing the right thing? By not doing the right thing, you get rewarded. That is not a way how planning should work. It is not a way how we should operate within this country. What it should be is that we recognise good authorities, we recognise the good work, we recognise the over-delivery, and therefore we take that pain away. And that pain should be a period to make sure that we have land in the longer term, not developing it in the short term. Because as we well know, taking all the safeguarded land now leaves us not only vulnerable, but no land available for what we will need in the future going forward. So it's very premature. It isn't the right thing to do, and it certainly hasn't been thought through. And this isn't the site that I believe we should develop. So what I would say once again is, please don't punish the authorities that have done the right thing. Don't put the burden onto them. What we should be doing is reducing the numbers, not developing the numbers. And everybody will begin to say, you might as well not do anything. Let everything go through appeal. Don't start putting land, because if you do the right thing, you'll take a kicking and a caning that you shouldn't have to take. And that's where it undermines the whole of planning within this country. And that's what I've been saying to the Secretary of State and Ministers. Get your act together. Get it sorted out. Don't punish the ones. It's no use patting us on the head and saying, oh, you're wonderful. What a great authority. Haven't you done everything right? And they agree with us. It's not fair. Well, we have a chance to make it fair today. We have a good chance for everybody to do the right thing by the residents within this area, but not just the residents of this area. You're doing the right thing by the people of Chorley, because it's the impact, isn't it? Once again, bringing things forward, shoving things through, school places, doctors, hospital, pressure on A&E. You begin to look at that. We've got the community health services. All of this is a burden that was not expected. So, what will we see? And I would say, are they going to provide a new doctors in Coppull? Well, I'd love to think so, but I suggest it won't be. Will they provide an extra school in Coppull? I suggest it won't be. And that's the problem, isn't it? That people will come, make money out of it, and I'm not against people making money. What I'm against is leaving a community with the extra strain, extra pressures that can't be delivered on. And that's what's always the easy way in here, isn't it? Developer comes in, builds the houses, walks away, puts the profits, pays shareholders off. Who picks up the problem? The problem is picked up by local authorities, whether that's county or whether that's district, and it certainly adds to my casework. And I don't need any more casework, so certainly what we should do is stand by the people that we all represent. So, after taking that forward with ministers, which they recognise, I believe that in light of it, it's not sustainable to apply the standard method to Chorley, and in order to allow genuine sustainable development which is plan-led. I encourage the inspector to recognise this unique situation Chorley is faced with, therefore determine that the 5-year supply should be based on the MOU policy or figures. I'm aware that as inspector that you've received representations from local residents, local councillors, that being the district councillors, county councillors, and I presume the parish will have also put their objections forward. And of course, in particular, one common theme was the concern relating to the highways and the access from Grange Drive onto Spedmore Lane. And I'm aware of the dangers of this. I know this area very, very well. It's been part of my constituency right back to 1997, so I've seen this site being developed. I saw the roundabout, which I do not believe was the right roundabout. I think the roundabout that we have should have been traffic lights, so it's never ever led to a safe junction. It's a very unsafe junction, and I really do support the residents on that and the local councillors. And I'm aware that you will be visiting this site, and I would ask you carefully to look at this junction and consider the poor visibility and the turning out of Grange Drive onto Spedmore Lane. I'm extremely disappointed with the County Council, but that's the story of my life, as the Highways Authority have failed to object on these grounds. But I think the problem there is that they would have to recognise they got it wrong in the first place. And sometimes people don't like admitting they got it wrong. Well, I can tell them they got it wrong very easily, because if they'd been serious about this junction, traffic lights would have been applied. And of course, the County Council will always say, well, nobody's been killed. Well, I don't work on that basis. I don't think that's good enough. I work on the basis, look how many knocks and bumps take place here on a regular basis. I've been stood there when people have run into the back of each other. Cars have pulled out, they've been clipped. It's only a matter of time before we have a fatality, and that's not what I want to see. So if you were minded, Inspector, and I do say only minded, and hopefully I think common sense will prevail from everybody that this isn't the right side, but if it was to be, surely we should see the major improvements of this junction, because that's part of what a condition should be if it was minded. The way to that is with a school, with a close proximity, shops as well, that really traffic lights with proper pedestrian crossings within this area would only help. It wouldn't be the solution, because the solution is not to build the houses now. But if you were minded, I think that's part of it. And the other thing that I would say is, and I've got to be honest, a major contribution towards a new school will be helpful. The setting up of new doctors. And I think the one thing that's key to Coppull, that nobody's brought out in this, that we are in major discussions with the government, with the rail minister, for the reopening of Coppull railway station, because the pressure on the roads is second to none. We've seen the increase of housing within the Coppull area and the greater Coppull area, and therefore the main line is available, and they take the pressure off the roads to ease the traffic congestion that is continuing, that is having major problems on the motorway junctions. Part of that, to alleviate it, personally, will be to see the reopening of this railway station. And developers have to recognise that they're not just in it to make money. They're here, if they want to go ahead to be providing housing, they've also got to provide infrastructure. And part of that infrastructure needs to relate to the railway station and the reopening of Coppull. That plan is being looked at now, not only with the district, but also, as I say, with the minister. I'm expecting a phone call and a meeting with the minister very shortly of how we can progress it. Well, part of that progression will be, if housing is going to go ahead, there should be a levy in order to put it towards this railway station. So that, quite rightly, the developers are wanting to play their part. So I'm sure they just don't want to make money. They also want to leave a sustainable area as well. So those would be the conditions only if you were minded to go ahead. So, as you can see, I've got great concerns about this. As a consequence, I appreciate this is not the reason for refusal on highway grounds, but it is a time that if people were minded to put it right. However, For the reasons outlined earlier, in relation to the land supply and protection and greenbelt, I would like to see this application absolutely refused and only brought on stream at the correct time in the future when it will be needed. Because the last thing we need is even more houses in our area. As I say, we're providing the housing for people as far away as Manchester, Liverpool, Preston, and way beyond that. Because when I knock on these doors, I knock on them and I ask the question, where are you from? And it's amazing how many of them are not local. So all we're doing is backfilling with people, and I don't mind people come live in this area. Why wouldn't you want to live in Chorley? It's a glorious town. It's a glorious place to live. We are in a very attractive area. But the reality is we're just laying more congestion in because people are coming to live here that then travel elsewhere to work. Because the one thing that Chorley doesn't do is provide the number of jobs that are needed locally. So we've got way over 50% of the travelling population working outside Chorley to go to work. Now, we are, and I don't like to admit it, but we are becoming commuter. Part of commuter means that puts more pressure onto all of your infrastructure. Hence why we need that railway station, we need proper junctions, we need to deal with the motorway junction at Standish that people use often, and it's about that creation, and that's why to bring more houses at this stage is totally premature. Thank you, Inspector.
Thank you very much, Sir Lindsay. We certainly do appreciate you taking the time to come and talk to us today. We appreciate that you are extremely busy. As you referred to in your statement, I have had a number of local people come to speak during the week. And I'm certainly going to take into account the comments that they've raised. And as you know, I will be doing a site visit later to in particular have a look at the site, but also look at the highway and the roundabout junction. So again, just thank you very much for coming to talk to us. Mr. Cannock, do you have any comments, questions, Mr. Lindsay?
No, thank you, Ma'am. These issues are well understood. They've been well tested, and I'll address them in closing.
Okay, then, thank you very much.
You said they've been well tested and well judged. So how have you judged the railway station and the need and requirement?
The what, sorry?
The pressure onto the infrastructure and the need to take the pressure off. At the railway station, have you brought that into your plan? Have you considered the requirement there, the requirement of the junctions? Because of the pressure of the amount of traffic that's now been creating, coupled due to the number of houses that's already been brought on stream. And this would only add to that burden. I'd be interested to know how that's been looked at.
Yeah, of course, Sir Lindsay, you will appreciate that one of the limitations of the public inquiry is that I'm not permitted to give evidence. So it's not part of the process that you have an opportunity to ask me questions. But without prejudice to that, in terms of the traffic generation, you will understand whether you accept it or like it. The process is such that we have made an application, we've submitted our transport assessment, it's been submitted by independent expert highway consultants, it's been independently audited by Lancashire County Council. Local residents have objected on a number of grounds, not least the junction improvements that you've mentioned. We've been asked for further information by Lancashire County Council, which has been provided again by independent expert highway consultants, which has then again been independently scrutinised by Lancashire County Council, as a result of which Lancashire County Council have no objections. The case officers at the local planning authority have no objections. The members, fully mindful, as I've asked the Councillor Wilson, in the light of the local residents, have no objections. And so our position quite clearly is there is no, in the MPPF terms, paragraph 109, no severe cumulative impact in terms of traffic concerns. In terms of the railway station, I'll have to take instructions on it, but so far as I am aware, at no stage in the lengthy processing and determination of this application has anyone suggested that we need to interrogate the prospect of delivery of a railway station. And so I'll take instructions. I don't think we've investigated that at all, because it's never been raised respectfully until you raised it a few moments ago, and we certainly don't consider that there's any capacity issue that this development needs to address in terms of doctors, dentists, etc. Again, I'm not aware of any objections from, for example, local GP surgeries, Primary Care Trust, NHS England, or any other statutory consultee or non-statutory consultee that has raised a capacity issue that this development needs to address. That's the best I can do to answer your question.
Well, just to say, on record, because in the end, we always talk to people that don't live in the area. We ask their comments. And I always think the best voice is the people that live there, councillors that are elected there, and whether that's parish, district to county, I think you will find it was a uniform voice against this application. And therefore, the people who are affected the most, I believe they're the ones I should listen to, not the people who do not live there and who are not affected by development. So I recognise that, of course, people, it's the easiest answer. I've always gone through this and done many planning issues over this borough for many, many years. The worst has always been, oh, don't worry, there's not a sewerage problem, yet somehow we have more spills into our local rivers on the grounds that North West or United Utilities never objected, because they never do. And that's always the weakness, that we never get the facts, we never get the truth. But I always listen to the local people. Not only are they honest, they actually are the ones that suffer, so they matter the most. I'll leave it at that. Thank you, Inspector.
Okay, thank you very much, Sir Lindsay. Right, you're welcome. Right, so next items on our agenda today then. We're looking at, I think we'll look first at the planning obligation. Yes, certainly, yeah.
Would it be okay if you just press your camera? I just want to check the cameras are okay for people who are going to be talking. Fine, yeah.
I look better as Melinda. And there's the evidence.
Right, thank you very much. Right, okay, planning obligation. I'm happy, as I said before, I've been handed a hard copy of that this morning. I have gone through this in the last few days, so I am aware of its contents and the obligations therein. One point in particular, am I right in assuming that there is now no contribution towards natural and semi-green space?
Yes,
That was in
ma'am.
an earlier version
Yes.
that I
That's
saw.
correct. It was a typo, Mum. It shouldn't have
Oh, it's
been in
typo,
there in the
right,
first
that's now
place.
gone, right, that's fine, I thought that was the case. The council's committee report actually did refer to the fact that there was no need for that contribution anyway. So that's fine. Does the appellant, Mr. Saunders, do you want to just briefly take us through this? Anything you wish to highlight?
Thank you, Mum. The only point I think we'd like to raise was in relation to the discussion yesterday on education. We heard the differences of opinion on, if I direct you to the 11th schedule. And the clause in there in relation to the way in which it will be calculated at the relevant point. Obviously, we're mindful of what happened yesterday, and we're working out whether it's required to add in, as interpreted by the inspector, into their relevant point, since you might find that it should be walking distance as opposed to, and that Wigan pupils should be excluded.
Is that not covered in the definition? The definition of the education contribution makes reference to the various options depending on my determination. Does that cover it? Or do you have a concern about the drafting?
No, it's something we're just trying to see whether it could be clearer, but are you okay in the definition? No, okay. No.
Yeah, I think just looking at the definition, it is what the actual education contribution may be.
I think that's right, Mom. If you look at page 10, the third box, apologies, I wasn't specifically instructed on this
No,
point,
that's
I think when you look at the secondary education contribution
Yeah.
means one of either A, B or C. I think that you can only resolve as between A or B, depending
Yeah.
on what conclusion you reach on the walking distance issue. So respectfully, Mum, I think that's right. I'll take instructions outside, but I'm not immediately persuaded there's an issue.
No, I don't think there is. And it does clearly say in the definition to be confirmed by the inspector. That will be the contribution, which then referred to in the 11th schedule in terms of how that is then calculated. I noticed in part 1 there, payment of contributions, it makes reference to the calculation of primary education contribution. I presume that's just to cover all eventualities in case circumstances change. At the moment, we're not looking at a primary education contribution. Is that
We're
just
not
a
asked. We're not
completeness?
asked. Yes, Mum. We're not asked for a primary
Yeah.
contribution.
Yeah, so just completeness that it's referenced in there, really. Right, okay. Right, I mean, it's fairly standard, I think, the clauses within this agreement and the schedule, just in terms of confirmation, what it actually requires in simple terms. Affordable housing at 30% on a 70-30 split. Social rent and what you might call intermediate housing, or fashion term, shall we say. Amenity green space contribution, which totals 86,100. That is required if it's not proposed to use a private management company to maintain the site. And then a completion notice is required, a final certificate, confirmation of how that open space is going to be managed. Children's and young persons contribution of £134 per dwelling to be spent on 3 areas of POS, which are defined in the obligation, one of which is the play area on Manor Drive, which is the most closest to the site, which is perfectly reasonable and most appropriate. A playing pitch contribution of £1,599 per dwelling. Is that for new or improved sport pitches within the borough? Are we able to define that in any more terms, or is it? No,
Yeah, I
don't
mean, I
know
think that the reference is made to the playing pitch strategy and the action plan to define the most appropriate pitch at the time. And I think that's what's referenced in the SIL
Yeah,
compliance
it's because
statement.
obviously they're pooled because rather than have them individually like we do smaller children's
Right.
play areas, they focus on hubs, larger hubs. I think there's 3 throughout the borough.
Right.
And obviously it depends what other developments are all coming forward and at what time they come on stream as to so it defines it as it references the action plan. So at the time that comes forward,
Right, okay.
it'll be allocated.
So for my information, which would be the nearest hub to the development site?
I can find that and let you know. Mel.
Yeah.
I have looked at it, but I didn't write it in here. I can get you a
Don't
note.
worry, it's just so I can ensure that it's a reasonable distance. So the contribution will be going to a site which would be reasonably used by potential future residents of this development. Okay, we've talked about education, which is fine. I don't have any other comments on the actual drafting of the obligation itself, but I just do want to touch on the SIL compliance statement, which the council have helpfully prepared, which is very helpful to enable me to ensure that it meets the tests of the framework and Reg 123 of the SIL regulations. Now that goes through each of those obligations and describes how they meet the individual tests, of necessity indirectly related to the proposed developments, and being fair and reasonable in terms of scale and kind, and compliance with the regulation 121 of the SIL regulations. Affordable housing, I think that's fairly standard. The site needs to be policy compliant. New reference is made there to the policy background. So I don't have any questions in relation to that. Can I ask, in terms of the amenity green space and provision for children and young people, there's a reference there to the Central Lancashire Open Space and Playing Pitch SPD. And it goes on to say development should contribute towards the improvement of provision where there are existing deficiencies in quality within the accessibility catchment of a development. So am I right in understanding that what this looks at is actually quality rather than quantity? So are we saying there is sufficient quantity of open space, but there is a quality issue? Yes, yeah, it goes through each element, doesn't it? Yeah. Right, okay. Okay. We've already established that this contribution will be spent potentially at 3 sites, one of which, as I said before, is the Manor Drive site. Manor Way, and Byron Crescent play area, or possibly Byron Crescent Mugger. So that's defined. The playing pick strategy, in terms of necessity, the fill statement describes the strategy identifying a borough-wide deficit of playing pitches. So there is an insufficient supply, but states the majority of this deficit can be met by improving existing pitches. Isn't that a little bit contradictory?
No, I think it's talking about, for example, if you've got a hub, you can, for example, if you've got a pitch, you could put 2 smaller pitches on it, so you can increase the provision of an existing hub without enlarging it, for example.
So it's increasing the provision at those hubs as well as the quality.
Yes.
Right, okay, thank you. The education contribution, we've already talked about this a little bit, but in terms of where those monies could potentially be spent, whether or not that relates fairly and reasonably in scale and kind to development, the suggestion is that it be spent at either Holy Cross High or Parklands Academy. What's the justification for those 2 schools in particular?
Those were the schools that were provided by LCC.
Okay, so presumably, am I thinking out loud here? Presumably those 2 schools are the ones that have either improvement extension projects in train that could potentially require contributions, have the capability to be expanded or improved, presumably. Yes. That's why those 2 schools have been highlighted rather than Southlands. I know Southlands potentially has the spaces. Overall, the catchment area doesn't if the county council's approach is adopted. So High Cross High or Parklands are the 2 sites that have the potential for improvement effectively and would serve the development. Right, okay. Thank you. I think that's all my questions actually in terms of the obligation. Any comments from either party?
Two, Ma'am. We're grateful for the input from the local authority, and we note that it's agreed as a mechanism, Ma'am. I told you that, and Mr. Ponter has helpfully agreed. The second point is it now needs signing. I'm told that, and I don't understand how these things work, but my solicitors tell me that it can be signed and distributed electronically reasonably easily. But can I nonetheless just ask for 7 days, simply so that you have a signed version? The wording will not change.
No, that's absolutely fine. That is quite common, to be honest. It does need to do the rights to get all the signatures. Electronic copies are acceptable. There needs to be a certified electronic copy. That's the only point I would make. That's normally our requirement from PINs to ensure that it is a valid copy, shall we say. Yeah, 7 days is fine with me. If you want to say 7 days from tomorrow, so a week tomorrow, end of next week, for a signed and certified copy, undated, obviously. From the council side, any comments?
None.
No. Okay, good. Thank you. Right, we'll move on to conditions then. Right, 2 minor points before we go through the detail of it. Firstly, can I be provided with an electronic copy of this agreed version of conditions, please, at some point? Yes, will do. That just help assist me greatly. I do have a hard copy here, of course. And secondly, the appellant, can you please provide in writing agreement to any pre-commencement conditions? Surely where that is required. Just an email through to the Pins case officer when you get a minute, that's all we need. Just to confirm that, thank you. So, in terms of the conditions themselves, who wants to lead me through this? Or is going to be the quickest way of doing this? Or shall I take the lead?
I'm happy either way, Mark.
We're giving you a rest today, Mr. Cannock.
We can review them.
Yeah, fine, carry on. I'll just find, there are a few questions I've got, particularly on the ecology conditions. But we'll have a look at those in a minute, so you carry on.
Yeah, okay. So the first condition is linking to the plans that have been submitted. That's probably all there is to say on that one. The second one is linking to reserved matters, so details of layout, scale and appearance, landscaping. Third condition is the time limitation, so it's been set at 2 years. And the reason that 2 years was selected is if it's being permitted on the basis of a lack of a 5-year supply, shorten the period so that it comes forward sooner. Fourth condition.
And can I just ask the appellant is content with that? Yep, thank you.
So the fourth condition is with regards to the open space to be set out on site. Fifth condition is with regards to the ecological appraisal that's been submitted.
Right, I said I wanted to ask about the ecological conditions because I found them rather confusing, to be honest, and quite repetitive in places. And you're smiling at me, so I suggest you also
This is
think
the
the
reduced
same.
list of ecological conditions, Mark.
I must have read these about 5 or 6 times to try
Yeah.
and understand them, what they're all each trying to achieve. But in number 5, is number 5 required? It's requesting an updated ecological appraisal. But then in condition 14, number 4, there's also a reference to that there. So I got a little bit confused, to be honest. We've got 14.4. It looks at demonstration there will be no negative impacts on the ecological status potential of the Tanyard Brook resulting from disposal of surface water post-development.
I think that's
specific.
14, that's specifically with relation to the surface water drainage as opposed to
Right.
a wider ecological appraisal, which is in condition 5. So
Right,
my
so it doesn't
understanding-
achieve the same thing then. This is just purely about the drainage strategy
Yes,
to ensure it has no negative impacts.
in terms of drainage rather than as a wider ecological impacts that could be.
Right, okay. I just wonder whether they could be tied up together in some way, but I'm not sure whether they can.
We have sort of discussed this at length to see if there was a way, and we couldn't find one, and that is
Yeah.
probably why they're set out how they are.
Right, I think I must admit I was struggling to try
Yeah.
and consider an alternative approach to try and simplify this, but it is a little bit difficult. Right. Okay, well, if I need to, I'll have another look at it, but I understand what you're trying to say. Yeah, okay, thank you. So, go on to condition 6 then.
So condition 6 is with regards to trees and bat roosting potential to ensure that there's no impact on bats.
Yeah.
Same again with condition 7 in terms of removal of hedgerow.
Right, does number 7, is that duplicated by 9 to an extent? Or is it again a nuance between the two? Number 9, in the 5th bullet point, looks at lighting control measures to minimise
I
the
think you
impact
perhaps
of
could
bats.
merge that within condition 9 actually, Mark.
Yeah, it's a bullet point 4 on condition 9, isn't it?
3, 4, is it 5? Bullet 5
Sorry,
on
1, 2,
condition
3.
9. So that is effectively covered by 7.
And for what it's worth, I'll chip in.
Please feel free, Mr. Hunter.
Condition 9 is requiring a series of steps to be taken before development commences. Condition 7 requires things to be done before any removal of hedgerows or trees take place. Now, that isn't development necessarily. So it's directed at two different points in time, potentially. That's my contribution.
Yes, no, I see the point you're making, but potentially, I suppose, the number 9, which is pre-commencement, will effectively cover 7.
Well, as I say, you could remove a hedgerow without commencing development, potentially.
True.
An internal hedgerow or a tree. Okay. Yeah, it's a question of how you read these, isn't it? And that they are, I appreciate they are quite interrelated,
very subtle,
but
some parts.
very subtle differences. And I suppose really what I'm trying to ensure is that we have as few conditions as we possibly need. To be fair to the appellant, who has got to actually comply with these and provide all the information and technical work behind them is quite significant, considering the number of conditions we've got here suggested. So anything we can do to try and put them down a little bit or simplify, I think is all to the good, but I'm not sure we're able to do that. Right. Okay, so are we going to leave condition 7 as it is then, bearing in mind that it is about removal of hedges and trees?
Yeah, and I think this is a similar point for condition 8, which is works to trees or shrubs not taking place in the nesting season. Condition 9 is the construction environment management plan, specifically in relation to biodiversity, so that has the links to the ecological appraisal.
Can I just, sorry, on number 9, you've got bullet point 6, is it? I can't remember. You have an A and a B. Is A and B necessary? The example.
Do you mean to just remove A and B, Mum?
Is it essential? Is it necessary for that condition to have that? Some of them are a little bit wordy and they sort of, you know what I mean? They include the justification and the rationale, the reason for the condition, rather than just simply being a condition.
Yeah, maybe. I think it's just to cover off exactly what we'd be looking for in that, because it could easily be lost over time.
I think it helps provide guidance for the developer in terms of what's expected to execute that condition.
I suppose as an authority, we would sometimes have put an informative note on, expecting, which obviously but we can't do that in this case.
So different, okay, I appreciate that. Okay, it doesn't actually, you know, it doesn't make the condition invalid or unenforceable, or it doesn't reach the test of conditions as such, but it simplifies.
Makes them quite wordy.
Yeah. Okay, I suppose it's a style issue, I suppose, to an extent. Right, okay, that's fine.
Okay, moving on to condition 10, which is the ecological mitigation enhancement plan. So ensuring that comes in and setting out what that would contain.
Okay, we have a strange and at the bottom. There's something missing. Actually, I looked at the statement of common ground. Actually, what that and then what follows after that in the statement of common ground for ecology is the reference to a 10% biodiversity net gain. What you've done is included something within the text above to make it policy compliant in terms of net gain rather than referring to 10%. So
I think that's why, because the appellant pointed out there was no policy requirement for 10% at the moment, which is why we linked it to policy.
So we'll just lose the and.
10%. Yeah.
Okay, thank you. Right,
And then
so 11.
Condition 11, landscape and ecological management plan and the contents thereof, including details of legal and funding mechanisms to ensure that happens. Condition 12, and in fact I think the next couple of conditions are all to do with surface water and flood risk assessment. They've all been requested by the EA or the LLFA. So the first one is ensuring that development takes place in accordance with the assessment that was submitted with the application. Condition 13 is to do with investigation works before development.
So what information do we have about potential contamination and the level of risk? The DOFIS study that the appellant produced suggested a moderate to low or even low risk, I think, from recollection.
I think it was a recommendation for environmental health that was a standard condition in terms of investigation attached to the condition.
Yeah, I appreciate it's a standard condition, but I'm just trying to establish, is it necessary? Certainly it is good practice in terms of precautionary measure, so it's a housing site.
Is it because the original report was mainly a largely desktop-based study, and this requires that once you
Yes,
go on
it was.
site to do more intrusive investigation?
Yeah, but that's, I mean,
Yeah.
that's the standardised approach. It's more, I think we've even condensed it from what it was, because it was, making out the site was a lot, well, contamination was more of an issue that really suggested it is off the desktop. So we thought that the language was unnecessary, but I think it's just something that's gone through. I'm happy to, the authority are on you, on that is removed as a precursor to the condition, but it doesn't preempt the outcome of the further work anyway.
Yeah, but I think I take the point the council makes that study, the application was a desk-based study, which didn't include any site investigations as such. So in that effect, it's precautionary. Yeah, so I'm content to keep it in. Yeah, okay, thank you.
And condition 14 is the foul and surface water drainage strategy, and setting out in the bullets what that should contain. Condition 15 is the final surface water sustainable drainage strategy.
Yeah, can I just ask about these two, because these two again I had to read quite a number of times. I think it's possibly how it's referred to, the strategy, because it is a little confusing, I think. Foul and surface water drainage strategy and a final surface water sustainable drainage strategy. It's defining the difference between the two. I understand what each is trying to achieve, because 15 really is looking at a sustainable drainage strategy, in line with the hierarchy, sustainable drainage hierarchy, which is fine. But in effect, is that not going to be covered anyway by the surface water drainage strategy if it is then determined that a sustainable approach is acceptable on that site depending on ground conditions? I'll be guided by you, your understanding of what each is trying to achieve.
Maybe it's possible we were looking at trying to merge conditions, weren't we? Would it be possible in this case? Because obviously 14 specifically says a foul and surface water drainage strategy.
Yes, because in one it refers to the hierarchy of drainage options, which potentially could be, which hopefully would be, the sustainable drainage strategy.
Yeah.
And the requirements are slightly different though, that's the difficulty. In 15,
The requirements in 15 are things like having no surface water discharging to the public foul sewers. So I think any clauses like that would have to be incorporated into 14 to make sure we weren't losing.
I think
elements of 15.
the difficulty arises when these conditions have come from the EA and the LLFA, and it's trying to they all ask for slightly different, and it's trying to combine the two, but make sure it covers both their requirements.
yeah. I think it's possibly the word final that I find more confusing than anything else. Maybe we could look at just referring them in different ways, just so it's clearer.
I'm not sure the word final adds very much.
But it makes it suggest that the first one's an interim, the foul and
Yeah.
surface water
I
one's
think
interim.
we
It's
would
not.
Leave the word
time.
final.
Yeah. Yes, that might help. Do we know, can I ask you a point, do we know what the drainage strategy is likely to be from your investigation?
No, Ma'am, only the initial investigations that have informed the Leeds Roxburgh drainage strategy team.
Right, so are we looking at sustainable drainage strategy in principle on the site?
Yes, Ma'am.
Right, okay. Right, okay. I think that's probably suffice, yeah.
Condition 16
Yeah, 16.
is management of surface water and pollution prevention during construction. Ensuring flows don't have any impacts on the site. Condition 17 is to do with disposal of foul waters, ensuring no foul waters go into the existing sewerage systems. Condition 18 is the maintenance and management plan for the lifetime of the development in terms of surface water.
Yeah.
Condition 19 is the verification report, operation and maintenance plan for the surface water drainage system. And I think that's the end of the LFA and EA conditions. Then we're moving on to local authority conditions again. So condition 20 is linked to the employment and skills SPD that's required for all development. So it's to ensure that a training plan is put in place. And condition 21 is the requirement to facilitate superfast broadband on the site. So it's not actually to deliver it, but it's to ensure that it can be brought forward on the site. Condition 22 is external facing and roofing materials for each phase.
Right. Is that necessary at outline stage? And it's interesting the way it's drafted in that for each phase, with any reserved matters application or prior to excavation of foundations.
We did have quite a discussion on this, and it's because of the experience we've had recently with material shortages that we've had some people putting forward with reserved matters, which you would expect when you were approving layout, and then finding that the materials due to the bricks, for example, they specified were not available, and then what do you do? They have to apply for that whole reserved matter again. So it was causing the authority sort of logistical problems. So that means that if they aren't able to get the approved bricks, then they can come on prior and they can propose a brick that they can access.
Right, so it gives the option, doesn't it, to come up?
It gives the option. So if they want to just put it in with the reserved matters, make it up front, that's fine. But if there are logistical problems later on, it shouldn't hold us up.
Right, I'm just also bearing in mind it's an outline application. So it would be a reserved matter, effectively, wouldn't it?
That's why that's the discussion we had, because this was exactly the discussion we had, wasn't it? That we would normally expect them with reserved matters as an appearance, but we have had the experience that it's causing developers problems with material issues at the moment.
Right, okay, I understand, thank you. Right, 23 then, this is about fences, walls, gates.
Yeah,
is that the same issue? Is that
same
the same
point.
reason?
Yeah, material.
Because normally we wouldn't be looking at a condition prior to construction of boundary treatments detailing the outline stage.
And same again for 24 Mom, in terms of hard landscaping.
Right, and 24 is in the same boat. Yeah, so all related to the availability of materials. Okay.
So condition 25 is looking at ensuring electrical vehicle charging points are available for each plot.
Is that necessary at this stage, or was it something you'd normally put on at reserved matters?
We would normally require it to outline, as we would consider that the outline consent was the planning commission, whereas the reserved matters was just the approval of details. So we would normally put all these conditions on an outline. It's not requiring a full electrical charging point, it is requiring that the hard wiring is available to allow future occupiers to put one in, considering how quickly it's likely that electrical vehicles are going to become mainstream.
Right, okay. Right, okay, yeah. Yes, just hard wiring, rather than the actual installation. Yeah, okay, thank you. Right, we're on 26 now.
26 is the dwelling emissions rate set at 19%.
And that is what's the policy basis for that?
It's policy 27 of the core strategy. It's due to, this gets quite complicated. It's due to the, I can't remember the act now, the deregulation act that came in. We can't, obviously the total sustainable homes have been abolished, but it still allows the council to do anything above building regulations to the dwelling emission in terms of energy efficiency if we have an adopted policy. So it's basically it's the policy 27 in light of the act, the deregulation act.
Right, okay. Yeah, no, that's all right. Thank you.
then
Oh, we
what's
seem to have lost
28, it should be
27, yes.
27. I'll change that in the
Never mind, we'll sort
electronic
numbering out,
version.
that's not a
sent
problem.
through.
We'll call it 28 for now, we can put numbering out later.
Yeah, so 28 is looking at the Estate Street and Phasing Completion Plan. So these are conditions requested by the County Council Highways Authority.
Right, okay. Just for precision, it refers there to no dwelling or dwelling shall be occupied. Should just be no dwelling shall be occupied.
Yes, I think so.
Yeah, it can be, yeah. Maybe into that, does it need to change later, that dwelling
yeah,
later on
to
as
that
well?
dwelling, yeah. Okay, so we're on 29
Yeah,
on this
that's, so
page.
29 is constructing base course level at the edge of the site to ensure that there isn't material taken off the site during construction. 31 is a survey looking at the existing roads around the site prior to construction, and then a follow-up survey post-construction to ensure that any damage that's been caused to the highway is remedied. And then 32 is the construction environment management plan, so looking at all of the bullet points
whole
below in
range of
terms of
measures
storage
there,
and
yeah.
access.
Can I ask you about A? Vehicle routing and parking of vehicles of site operatives and visitors. But then later on, we've also got routes to be used by vehicles carrying plants and materials. I think parking is legitimate. I'm just a little bit, I want to query the vehicle routing for site operatives and visitors.
I mean, would it be more sensible to remove vehicle routing and just have the parking of vehicles of site operatives and visitors on as A?
That's what I'm thinking. I'm just wondering why it is necessary
The vehicle
to
routing of
include vehicle routing for site operatives and visitors in particular.
Yeah, whereas it
I
would be
think
more,
so,
whereas
yeah.
the routing is more to do with
Routing is to
heavy
do with heavy
vehicles.
plants and materials coming, isn't it? Yeah, rather than, so vehicle routing could come out of there.
Yeah.
So it's just,
Start at
it's just the parking of
Yes.
operatives and visitors that's the
Yeah.
issue,
Yeah.
Right, thank you.
And then condition 33 is the off-site highway works that are taking place and the tactile pavements being installed. Condition 34 is,
Right, so that includes both access and off-site works, doesn't it?
it does, yes,
Can
so
I
that's
try
the
A and
two
B there?
sub-bullet points.
Yeah, so that's point B.
Yes,
I think there's a typo,
I'll do A and B.
A and B is repeated.
No, we've got two A's, two B's, doesn't matter. Yeah, that can be resolved.
Yeah, and then condition 34 is the site access.
Yes, that's the commencement and completion, yeah.
Condition 35,
The off-site, isn't it? Works,
off-site
yeah.
works. And then condition 36 is a travel plan, and then linking that to a 5-year period. And then condition 37 is an archaeological condition, just as investigative works before
Yeah, and
development
yeah,
commences.
recording of any finds.
Yeah.
Okay, that's fine. Very comprehensive list.
Would have been a lot longer, wouldn't it?
At least you had tried to reduce it down.
That is the Slim David.
Yeah, that's all my comments on conditions. Are we all content? You're content with that? Yeah, oh, good, excellent. Okay then, so that's all I need to do, covering off those. So, I know Mr Cannock, he wants a little bit of time to work on your closing, which is perfectly reasonable. We are now on 10:30, so we're not doing too badly. So when would you like to reconvene? You suggested 12:30 yesterday.
I'd be very grateful. I'd be perfectly content with that amount of time. Mark,
12:30 and just
yeah.
have an early lunch and start at 12:30. I'm happy with that. Mr Ponter? Right, okay then. In that case then, thank you very much for now, and we will adjourn until 12:30 and we'll come back to close the submissions. Thank you. Right, thank you very much, everybody. Time is now 12:30, so we are resumed. So we now turn to closing submissions. So first of all, is there anything before we start, Mr.
Just one
Potter?
point, Madam. Your question about that arose out of Councillor Wilson's evidence concerning, I think, white land,
Yeah.
if I can call it
Yeah,
that. There is none.
right.
I've got
That's easy
figures for
answer.
how much greenbelt safeguarded land and area of other open countryside there is, if that would be of interest to you.
Yeah, I'll have the figures if
Right.
we've got them.
Greenbelt, 14,560 hectares, I'm rounding up.
Yeah, that's fine.
Safeguarded land, 145 hectares.
Yeah.
Area of other open countryside, and that's a policy designation,
Yeah,
BNE
okay.
2, 2,825 hectares.
That's helpful, yeah.
That's my only housekeeping.
That's super, thank you. Right then, closing submissions. Council first, Mr. Ponter. Thank you.
These have been emailed.
Oh, right, okay, fine. Ah, good.
And, Madam, given the parties present, I'm going to rattle through these. I'm not going to read out the footnotes,
That's fine, yeah,
and I may skip over some of the passages
that's
and
no
leave
problem.
you
Yeah,
to read them in your own.
I can
time.
certainly do that.
Thank you very much. Starting, please. There's no dispute between the parties that the appeal scheme is in breach of the development plan. And the fourth of the main issues that we identified at the start of the inquiry recognises that fact by, in effect, asking whether or not there are material considerations that overcome that breach. It's implicit in that there is a breach. Before I come to the first two main issues, and those are relevant to the question of 5-year supply, I'm just going to restate a few points which I think are uncontentious. Firstly, the appeal is to be determined in accordance with the development plan unless there are material factors to the contrary. Secondly, the undisputed conflict with the plan arises out of the fact that the appeal scheme, I should read, comprises the permanent development of safeguarded land during the currency of the plan period. And thirdly, the appeal, I thought I got all of these, clearly not. The appeal also generates conflict with up-to-date national policy and conflict in respect of the protection of safeguarded land. And I give the reference, it's 143D of the framework. As to that last point, and I'm going to come back to the planning balance, obviously, at the end of this, I just recall the fact that the appellant's evidence, and those are the proofs of Mr. Saunders in particular, fails to record at all the fact that the appeal scheme generates a significant breach of national policy. Mr. Saunders accepts that national policy attracts significant weight, as does its breach. However, the significant breach of national policy generated by the scheme is simply missing from his assessment. I just recalled in the footnote that the suggestion that, well, it's in there implicitly is not good enough, quite frankly. The concept of safeguarded land is long established. It's an important tool in maintaining one of the two essential characteristics of the Greenbelt, namely its permanence. The Council's local plan recognises that fact and confirms that the purpose of its safeguarded land is to ensure that its Greenbelt boundaries are long-lasting. I give the reference. The expectation of national policy is clear. When Greenbelt boundaries are defined in a development plan, there is an expectation that they'll not require alteration at the end of the plan period. As a matter of generality, and I'll come back to the specific circumstances shortly in a moment, the less safeguarded land that's available when a plan is reviewed, the more likely it is that Greenbelt boundaries will have to be reviewed in order to accommodate new development. It goes without saying. It's in the interest of Greenbelt permanence that safeguarded land policy is unequivocal and contains a clear prohibition against its development during the planned period. Accordingly, as a matter of principle, we say it's right that a clear and significant breach of that policy should attract significant weight in the determination of this appeal. There's no basis for reducing that weight because a particular site is a potential candidate for housing allocation in an emerging plan. That appears to be the underlying theme throughout the appellant's case. The appellant assumes that the appeal site will benefit from an allocation in the next local plan. And this proposition has been repeatedly advanced during the course of the inquiry that come the next local plan, the site will either be an allocation with planning permission or an allocation without. And on that basis, no harm flows. Of course, that approach is directly contrary to national and local policy for safeguarded land, point one, subverts the plan-led system, point two, and thirdly, is obviously misconceived. The emerging local plan in central Lancashire is at a very early stage and can attract only limited weight. There's no certainty whatsoever attaching to the allocation of this site, or indeed any other site, in the next plan. Likewise, the fact that the appeal site faces no technical constraint in respect of its development, and if it did, it wouldn't have been designated as safeguarded land in the first place, is not a reason to grant planning permission for development. Self-evidently, that approach and argument would render the policy protection given to safeguarded land entirely worthless. So, housing land supply. The central dispute between the parties in this appeal and in respect of housing land supply concerns the proper identification of the requirement against which supply should be assessed. Obviously, there's a much narrower dispute as to the level of supply, and it's 127 dwellings between the parties. With our assessment at 1504, the appellant's 1377. I'll come to the contested sites, but perhaps not read it out, but deal with them, but briefly, because it makes no material difference to the outcome of this appeal. So the housing requirement first, and I'll deal with relevant national policy and guidance. The agreed starting point is paragraph 74, and it sets out two options that I recalled in the sub-paragraphs at 13. Of course, as I say over the page, option 2 comes with the important caveat in the footnote, number 39, relating to reviews that find policies don't need updating. PPG gives some more detail, and again, Madam, I set out the relevant extract. You've got that at CD 5.5. And it's clear, as accepted by Mr. Saunders, where strategic policies are more than 5 years old, but have been reviewed in the last 5 years and found not to need updating, the housing requirement figures in those strategic policies should be used. There's no caveat in national policy or guidance to the effect that that approach should be modified where the review of strategic policies has been followed by introduction of the standard method. If the government had thought a caveat was required, then it would have introduced one. Moreover, and as accepted by Mr. Saunders, it's obvious that the provisions of the PPG that I've referred to will include reviews that predate the introduction of the standard method in 2018. That's unavoidable. And so, as I say over the page, the undeniable outcome of the application of national policy and guidance is that in circumstances where a review of strategic policies has occurred within the last 5 years, those policies found not to require updating, the housing requirement to be used in the calculation of the 5-year supply is that within the strategic policies. Council accepts that as a matter of judgment, there may be material factors that mean individual decision makers, particular areas, may choose to apply a local housing need figure instead, notwithstanding the fact that a review of strategic policies has taken place within the last 5 years. However, there is no dispute that national policy and guidance are material considerations that attract significant weight. As such, there should be cogent reasons to depart from their terms. Next point is whether or not there's been a footnote 39 review, and I'll deal with this relatively briefly because it's not disputed. It's agreed in this appeal that the Central Lancs authorities conducted a review of strategic policies in 2017. They commissioned a SMART, they produced the Memorandum of Understanding in 2017, referred to as MOU1 in this appeal. And that review found that the housing requirement within the Strategic Policies Development Plan didn't need to be updated. That position is consistent with the two most recent and relevant appeal decisions for schemes in central Lancashire. So in the Cardwell Farm appeal decision, both parties agreed that MOU1 comprised such a review, as did the inspector, and precisely the same position in the Chain House Lane decision. By contrast, the Pear Tree Lane appeal decision didn't proceed on the basis that MOU1 comprised a review of strategic policies for the purposes of paragraph 74. However, the parties in that appeal didn't present the inspector with an agreement that MOU1 comprised such a review. The reason for that is clear, since at the time, the council, in common with the two other central Lancs authorities, was relying on the second Memorandum of Understanding for its housing requirement figure. The Pear Tree Lane inspector was presented with a binary choice in terms of housing requirement, either the solar standard method figure or the redistributed standard method figure in MOU2. And as a result, the Pear Tree Lane inspector wasn't asked to determine whether or not MOU1 comprised a review, therefore didn't reach any such determination. What the inspector did do there was reject MOU2 as a proper basis for establishing the housing requirement for Chorley, on the basis that an exercise of redistribution of local housing need is a matter for the emerging local plan as opposed to development management, and MOU2 was given limited weight. Given that, the debates has moved on since the Pear Tree Lane decision. In particular, in light of that decision, Chorley quite properly doesn't place reliance on MOU2 as the basis for calculating its housing land supply. And as is clear from the two subsequent appeal decisions I've referred to, all parties and inspectors now accept MOU1 to have comprised a review in accordance with national policy. I turn then to the appellant's apparent reasons for supplanting the review, it being required to be used by national policy. Thus far, it's clear and agreed that national policy and guidance confirms that the housing requirement in strategic policies should be used for the calculation of 5-year supply, where those policies are more than 5 years old but have been reviewed in the last 5 years. And it's clear that a review in accordance with the framework has taken place in the last 5 years. And so against that background, Mr. Saunders expressly agreed the straightforward application of planning practice guidance means that the policy 4 figure should be used as the housing requirement for calculation of the 5-year supply. So against that background, it's for the appellant to demonstrate there are clear reasons to depart from the application of national policy and guidance. And I set out, I don't read this list, but I set out what the appellant's apparent reasons appear to be. I've tried to summarise them as best I can. I address them as follows. First, there is nothing in MOU1 to the effect that it expires after 3 years. And I set out its relevant provisions, which include its continuation until the adoption of a replacement local plan. So insofar as it has a shelf life, it's until the adoption of that plan, and that position hasn't yet been reached. We recognise that paragraph 7.1 of the document says that it will be reviewed no less than every 3 years, and it'll be reviewed when new evidence renders it out of date emerges. That provision, together with the fact that MOU1 is now more than 3 years old, doesn't render the review out of date. We make the following points. Firstly, neither the Cardwell Farm inspector nor the Chain House Lane inspector concluded that MOU1 should be considered out of date because it's more than 3 years old. Secondly, the Central Lancashire authorities conducted a review of MOU1 in 2020 and produced MOU2. However, as we've already addressed, it's MOU2 that's been confirmed as attracting limited weight and is no longer relied upon by the council or indeed the two other councils. And three, whether or not the emergence of the standard method housing requirement since 2017 comprises new evidence that renders MOU1 out of date, we'll come back to, but it's sufficient to note at this stage that we point to specific factors in Chorley, which means that's not the case, and the Cardwell Farm Inspector didn't consider that the emergence of the standard method housing requirement in Preston rendered MOU1 out of date. Secondly, it's accepted that MOU2 and the 2020 housing studies state that application of the Policy 4 housing requirements is out of date. However, MOU2 has been found to attract limited weight, accordingly isn't relied upon by the council, or the other councils. Even if MOU2 attracts more than limited weight, and there's no reason why it should, there's nothing within its provisions that suggests the use of the solar standard method figures for each of the local authority areas in the event that Policy 4 figures aren't applied. Thirdly, notwithstanding the statements in MOU2 and the 2020 housing study, the Cardwell Farm Inspector didn't conclude that application in Preston of the Policy 4 requirement was out of date. And lastly, the Chainhouse Lane Inspector didn't conclude that application in South Ribble of the Policy 4 requirement was out of date simply because MOU2 and the 2020 housing study said so. Thirdly, the appellant's contention that application of the Policy 4 housing requirement is out of date because of an out-of-date evidence base and reliance on the regional strategy is obviously misplaced. We repeat the fact that it's agreed that MOU1 comprised a footnote 37, now 39 review. It was based on an up-to-date assessment of housing need contained within the SHMA. Whatever the age of the evidence base that informed the original identification of that requirement, the 2017 SHMA comprehensively updated it. Accordingly, the review of strategic policies that culminated in MOU1 wasn't based on out-of-date evidence or an out-of-date regional strategy. As we've already recorded, the government's PPG anticipates that such reviews, based on up-to-date evidence, should last for 5 years. The last two of the 5 reasons that I've summarised at paragraph 29 above appear to comprise the appellant's central contentions, and I address them as follows. There's no dispute that the introduction of the standard method as the basis for establishing a housing requirement as the starting point for identifying development needs in an emerging plan is relevant in deciding what housing requirements should be applied in the calculation of 5 years supply. We don't say it's irrelevant for 1 second, it's relevant. There's also no dispute that the direction of travel in terms of housing need for the Central Lancashire authorities, the preparation of their emerging local plan, starts with local housing need, calculated by reference to the standard method. That's no surprise. Paragraph 61 of the framework tells us to do that. Central Lancashire's emerging local plan confirms that its starting point in terms of housing need are the figures generated by the standard method. The emerging plan is equally clear that the 3 authorities will work together in order to achieve an agreed distribution of those figures, taking into account a whole series of factors, and I quote from it. The fact that new local housing need requirements calculated in accordance with the standard method are to be the subject of distribution is equally of no surprise. The housing study of 2020 identified local housing need figures for each of the 3 authorities. It then proceeded consider an appropriate distribution of that need by reference to a variety of factors, including where the population is, workforce, jobs, relative affordability of housing, environmental constraints, and so on. Distribution of each of those factors is markedly different from the distribution of housing need if solely the standard method figures for each of the 3 authorities is applied. As a result, the 2020 study comes up with a recommended distribution of local housing need that looks very different from simple application of the SOLAS standard method figures for each of the authorities. Accordingly, whilst the direction of travel for Central Lancashire in its emerging plan, in accordance with the framework, is the use of the standard method to calculate local housing need, there's no evidence to suggest that the likely destination is application of the SOLAS standard method figures for each of the 3 authorities. On the contrary, the evidence demonstrates the likely destination to be a significant redistribution of that need. There are some additional reasons for upholding Policy 4 and MOU1 in Chorley. we say that the appellant has failed to demonstrate why the policy 4 requirement endorsed by the review of MOU1, the use of which conforms with national policy in the PPG, should be supplanted by the standard method in this case. In addition, it's clear that there are reasons specific to Chorley that support the continued use of the policy 4 housing requirement. I've already referred to the fact that simple application of the SOLAS standard method figures gives rise to a distribution of housing across central Lancashire that fails to reflect the distribution of population, workforce, jobs, relative affordability, environmental constraints, as well as other factors referred to in the 2020 study. I set out the figures referred to in the study as the standard method figures at that time, and I don't read those out. And they compare with the policy 4 requirements that I similarly set out. The answer as to why the standard method skews needs so heavily in the direction of Chorley is clear, confirmed by the 2020 study. Calculation of local housing need using the standard method is informed by the 2014-based population projections that are in turn particularly influenced by the level of development from 2009 to 2014. The figures for housing completions for that period across the 3 authority areas are stark, and it's perhaps the percentage levels that is most stark. And I say at paragraph 52, the fact that Chorley was able to deliver 60% of central Lancashire's new housing from 2009 to 2014 is not a good reason for requiring Chorley to deliver 57% of central Lancashire's new housing from 2021 to 2026. And that's the effect of imposing the SOLAS standard method figure. That point is given even greater force when it's recognised that the strategy of the development plan anticipated strong early delivery of housing in Chorley, with diminishing levels of delivery as the plan period progresses and as housing completions in other parts of central Lancashire increase. I quote from the local plan, I don't read that quote out, and I give the reference. Recorded housing completions in Chorley are broadly consistent with the projected trajectory in the local plan. In other words, strong early delivery in Chorley, as anticipated in that plan, has been realised. By contrast, the core strategy anticipated delivery at other strategic sites and locations would increase during the planned period. I give the example of North West Preston. The reasons for that are clear and obvious. Buckshaw Village, for example, was an active development site at the beginning of the planned period, delivering dwellings already in 2010, and by contrast, other sites and locations were greenfield and awaiting substantial infrastructure before they could get out of the ground. In other words, the spatial strategy of the plan, including the anticipated timing of the delivery of housing, reflected and continues to reflect the early delivery of housing in Chorley with diminishing completions in the later parts of the planned period. And all of those factors identified in MOU1 as supporting the continued use of Policy 4 remain of relevance to the question of housing delivery in Chorley, and in particular, an apportionment of housing need that reflects the spatial pattern of development set out in Policy 1. The last factor that supports continued use of the Policy 4 figure for Chorley concerns the need to protect safeguarded land from development during the planned period and in accordance with policy. We've already noted that the SOLAS standard method figure for Chorley is higher than the Policy 4 requirement. By contrast, those figures for Preston and South Ribble are significantly lower than their Policy 4 figures. And secondly, Chorley is significantly more constrained, including by Greenbelt, than either Preston or South Ribble. As a result, there is a significant risk that arises in Chorley through use of the standard method figure that doesn't arise in Preston and South Ribble, namely the prospect of there being no 5-year housing land supply with an associated risk to safeguarded land. That risk is apparent in the raft of planning applications for the residential development of safeguarded land since issue of the Pear Tree Lane appeal decision. Though we requested that the Secretary of State call in all applications, and that was in July, in order to take a comprehensive view of the consequences generated by those applications. That request was met with silence. The danger now faced by the Council is a series of individual decisions in which each of the applicants or appellants maintains that the release of its site poses no real risk. In summary, and in addition to the clear requirement of national policy and the guidance to use the policy 4 figures, the Council points to the following factors. Application of the solar standard method for Chorley means that it's expected to accommodate nearly 60% of central Lancashire's housing for the next 5 years. That level of provision fails to reflect any relevant factor in respect of the distribution of housing. Secondly, the standard method figures are largely a product of housing delivery in 2009 to 2014, during which period delivery in Chorley was particularly strong. The fact that Chorley delivered around 60% of central Lancs housing from that period provides no rational justification for requiring to deliver almost 60% of central Lancashire's housing in the next 5 years. That is particularly so in light of the fact that strong delivery in the early part of the planned period, with decreasing delivery later, was precisely what was anticipated in the development plan. Fourth, application of the solar standard method figure for Chorley fails to reflect the spatial strategy of the development plan, including the timing of its delivery. Application of the solar standard method figure for Chorley generates a significant risk to safeguarded land. Having concluded that the policy 4 requirement should apply to Chorley, the next question to arise concerns the treatment of oversupply from previous years. I'll address that next. The question of whether or not previous years' oversupply should be taken into account in setting the requirement for a 5-year assessment isn't unique to Chorley. It's arisen elsewhere and is the subject of several appeal decisions, I'm afraid to say, all of which are before you, Madam. It's common ground that neither national policy nor guidance contains advice on this issue, and I quote from Inspector in the Middleton Cheney decision. And as such, the appellant accepts that it's a question of judgment as to whether or not the 5-year supply requirement is adjusted to take account of previous year's oversupply. And I'm going to address the factors in Chorley that mean that it should be taken into account. Before I do that, a couple of important points in the appellant's case. First, Mr. Saunders adopts the position that the lack of national policy or guidance means that central government agrees with him that oversupply should never be discounted. With respect, that argument of his is entirely misconceived. If central government agreed with that approach, then it would have amended its guidance to that effect. The absence of policy or guidance confirms that central government is content that a judgment is to be reached by individual decision makers. Second preliminary point as to the appellant's case is this. Mr. Saunders adopts the position that the national policy objective of achieving a significant boost in housing land supply means that oversupply should never be offset against the 5-year requirement. If that is right, then there is no planning judgment to be reached in any local planning authority area in England, and self-evidently that's wrong. I next turn to the factors which justify the position in Chorley. Firstly, Chorley's housing requirement for the planned period is at least 6,834 dwellings. In the first 11 years, Chorley achieved 6,316 completions. In the next 5 years, it will supply either just over 1,500 or just short of 1,400 houses, depending on whose supply case you prefer. In either case, by the end of the planned period, the minimum requirement of 6,834 will have been significantly exceeded. Moreover, the local plan requirement of 6,834 dwellings was endorsed against the requirements of the framework, including the need to achieve a significant boost in land for housing. And as such, delivery of 6,834 dwellings in Chorley over the planned period will represent a significant boost. It goes without saying that delivery of well over 7,500 dwellings, which is what's going to be achieved, will likewise represent a significant boost in housing land supply in Chorley. There's no answer to say that because paragraph A of policy 4 is expressed as an annual figure, then the 5-year supply should be measured against that annual figure. First of all, the need for housing in Chorley identified in the development plan is a need that arises over the planned period, and I've given the figure for that. Self-evidently, it's not a need that arises on an annual basis at a steady rate of 417 dwellings. If, over the planned period, at least 6,834 dwellings are provided, then Chorley's need will have been met. Equally, if a position of undersupply emerged from previous years, then everyone would be expecting the council to make that up in future years, as opposed to rigidly sticking to an annual delivery rate of 417 dwellings. The reason for that is obvious. The fundamental need to be met is the planned period housing requirement. And it's for that reason that the appellant's reliance on the housing delivery test is misplaced. I just note 2 points. The housing delivery test looks back over only the last 3 years. It tells you nothing about delivery of the planned period housing requirement over that planned period. And secondly, not a single inspector who's grappled with the issue of what to do with oversupply has suggested that the housing delivery test provides the answer. Likewise, whilst policy 4C requires the maintenance of a 5-year supply, consistent with national policy, I'd add, it's silent on the calculation of the housing requirement and how the consideration of oversupply fits into the assessment. Secondly, as I've already addressed, the spatial strategy for Chorley in Chorley's local plan expressly anticipates strong early delivery as compared with Preston and South Ribble, with delivery decreasing in later parts of the planned period. The local plan was endorsed on the basis of a trajectory that showed by 2021 there would not be delivery of at least 417 dwellings per year. That's because of strong early delivery. No suggestion that the local plan inspector was dissatisfied with that approach or considered it to be inconsistent with the core strategy. Third point, as recognised generally by the Middleton Cheney inspector, a failure to take into account previous year's oversupply could lead to an artificial inflation of the housing land requirement, a lack of 5-year supply, engagement of the tilted balance, and the provision of housing in inappropriate locations. I give the reference. That's a real risk in Chorley, since unconstrained land for development is not readily available. In particular, as is clear from the record of planning applications since the Pear Tree Lane decision, safeguarded land becomes the target for proposed development. And finally, as again noted by that inspector, the artificial increase of the overall plan period requirement undermines a proper plan-led approach to development control. That is, again, specifically the case in Chorley, where the development plan expressly anticipated strong early delivery. So our conclusion on the housing land requirement is that the policy 4 figure prevails. Supply, Madam, I don't read out. I set out in very brief terms the position on each of the disputed components of the supply. I do note what I say at paragraph 83, that quite apart from the level of housing land supply, the appellant seeks to introduce doubt as to the adequacy of the quality of that supply. We say that that suggestion of doubt shouldn't be accepted. Mr. Saunders agrees that whatever the precise level of supply, all of those houses will contribute to meet housing needs. There's no analysis to support any different conclusion. So with all of that in mind, we say there's 13.8 years worth of housing land supply. Next issue is whether the most important policies are up to date. And again, given the evidence we've heard, I can deal with this briefly. Firstly, our position is clear. Where there's an adequate supply of land for housing, the tilted balance of paragraph 11D of the framework isn't engaged. I then set out Mr. Saunders' contention that policy BNE3 is out of date for 2 reasons. And you'll recall, Madam, those are at his paragraph 653 of his planning proof, and I set them out, I hope, accurately. He also quite properly accepts that if the council is right in respect of the housing land supply arguments, that is, that the policy 4 figure as reviewed in MOU1 isn't supplanted by the standard method figure, and the consideration of oversight supply means that a 5-year supply exists, then BNE3 is up to date. So, Madam, I just add there an awful lot of evidence about the background to the Policy 4 figure, regional strategy and its evidence base. Whether or not settlement boundaries are constrained, whether or not as a result they're out of date. All of that with respect goes out of the window, because Mr. Saunders and I agree that if we're right on MOU1 and oversupply, then his arguments for BNE3 fall. That's the end of the matter with respect. And as I sum up at paragraph 88, in circumstances where the Policy 4 requirement is applied and the Council can demonstrate an adequate supply of housing, there is effectively no dispute that the most important policies are up to date. Conventional balance should be applied in the determination of this appeal, and I turn to that next. We recognise the appeal scheme's benefits. Provision of market housing is a benefit, but in circumstances of plentiful supply, it should attract limited weight. Obviously, if you conclude shortfall, then significant weight, as Councillor Wilson set out in his evidence. By contrast, Mr. Saunders adopts an approach that takes little account of the relationship between an increasing level of supply and the diminishing level of benefit associated with the delivery of even more housing. The appeal decisions relied on in his proof of evidence provide him with no support. In fact, they readily demonstrate that as housing supply increases, the weight to be given to the provision of more housing, quite properly, is reduced. Secondly, the provision of affordable housing represents a benefit. The difference between the parties as to weight is marginal, where it's significant, the appellant very significant, and on the evidence given for both parties doesn't affect the outcome of the planning balance. There's no doubt, in common with many other authority areas, that there's a significant need for affordable housing in Chorley. And in recognition of that fact, the Pear Tree Lane inspector attributed significant weight to the provision of affordable housing in respect of that appeal. Since issue of the Pear Tree Lane decision, the affordability of housing in Chorley has improved. That change is confirmed by reference to the clear pattern of improving affordability as demonstrated by the diminishing level of the calculated local housing need figure. The baseline for that calculation is constant. The affordability adjustment varies. And in Chorley, the affordability adjustment reduced from 2019 to 2020 and from 2020 to 2021. Mr. Tatton's proof of evidence didn't consider that issue, and he accepted that it paints a picture of improving affordability of housing in Chorley. We accept, of course, that the number of people on the housing register has increased substantially since the Pear Tree Lane decision. It appears to be associated with the pandemic, as confirmed by Mr. Tatton. It can't be concluded that the recent increase represents either a trend or even a persistent level of numbers on the register. In any event, the number of people on the housing register isn't the need for affordable housing. Accordingly, significant, we say, as opposed to very significant weight attaches to the provision of affordable housing. Thirdly, economic benefits associated with the construction of houses and spending by future residents, to which we attach limited weight. Biodiversity, not quantified and therefore limited weight. And similarly, with regard to open space, without clear evidence as to the likely level of benefit as a result of actual use by residents, limited weight. In order to justify the grant of planning permission, the benefits generated by the scheme must be sufficient to overcome the clear conflict generated by the scheme with the development plan and national policy. And in our view, they fall short. Conflict with the development plan in the framework is not trivial. The release of safeguarded land on an ad hoc basis during the planned period diminishes that resource and undermines confidence in the plan-led system. It's no answer to suggest that no harm arises from the grant of consent because there is, in effect, no difference between an allocated site in the next local plan that has planning permission as compared with a site which does not. No party knows what Chorley's housing requirement will be in the next local plan, nor the scale of required release for allocation, nor whether this site will be allocated. In those circumstances, there's clearly no justification for the release of safeguarded land in breach of the plan and national policy. The suggestion that the provision of market housing in the face of a plentiful supply, the provision of affordable housing in circumstances of significant but not unusual need, is sufficient to overcome that policy breach, we say, is not credible. Such an approach would render national and local safeguarded land policies worthless. Finally, in circumstances where the tilted balance is engaged, harm must significantly and demonstrably outweigh benefits to justify refusal. We addressed negative and positive impacts of the appeal. It remains our firm conclusion that the appeal generates harm and policy conflict that significantly outweighs benefits, and I request respectfully, Madam, that the appeal is dismissed. I hope I've not raced through that too quickly.
No, that was just nice. Thank you, Mr. Ponter. Right, Mr. Cannock. Thank you. Right, so when you're ready.
Just a few preliminary points, if I may. I'm not going to engage in the tedious exercise of going through Mr. Ponter's closing submissions in the manner of some advocates. It's an approach which I think should be deprecated. You're more than capable of noting where I disagree, but I may just have a couple of notes as we go along. Second point, where I set out quotes, please read them in full in their context. I wouldn't want any selective quoting. I don't think there is any. All of my quotes have been footnoted for that purpose. Thirdly, I refer to a number of concessions made by Councillor Wilson. Please check your notes. The concessions are consistent with my notes and the notes of my team. But check your own notes. But lastly then, Ma'am, please could you just note in Malone and Friends closing submissions how few concessions in his case he references. With that said, Ma'am, I'm not going to read every word of this. I'm mindful of the time. Stopwatch is at the ready. I'll go through this as quickly as I can. Mindful, Ma'am, seriously, that you're very familiar with the information here, but hopefully this is a useful aid memoir for you to take away.
It is indeed, yeah, it is very useful to me. Yes, thank you very much.
The context for this appeal is the national imperative to boost significantly the supply of housing. There's a recognition from central government that the planning system has simply failed to deliver sufficient homes for a protracted period of time, and this can no longer be tolerated. The housing crisis, a daily news story, has been expressed most recently in white papers entitled Fixing Our Broken Housing Market and Planning for the Future. The government's response has been, amongst other things, the requirement for authorities to plan to meet as a minimum their local housing need derived using the standard method. The local housing need for Chorley is 537 dwellings per annum. Applying it, Chorley have a mere 2.4 to 2.6 years. By contrast, Chorley are planning to an annualised requirement of just 104 dwellings per annum, resulting in a collapse in the delivery of market and affordable housing. The appeal site was designated as safeguarded land since 1997 because the authority accepted its development would constitute sustainable development. Their position has not changed in the intervening 25 years. The authority do not allege any tangible land use planning harm from the development of the site. On the contrary, it's agreed that the site comprises a sustainable location for housing development with no technical constraints or objections from statutory consultees. This is a proposal which delivers the significant benefits of more market and affordable homes with substantial economic benefits on an accessible site adjacent to a wide range of facilities in Coppull without any land use planning harm beyond the inevitable impact of placing housing on a greenfield site itself specifically identified for housing development. This is the form of sustainable development which national policy strongly supports. Indeed, it's telling that professional officers from the authority do not support the council's position, leaving Councillor Wilson to defend it. Significant weight should therefore attach to the consensus of professional evidence that planning permission should be granted. I then turn to the appeal proposals, the reasons for refusal with which you're familiar and how they've been addressed, the main issues with which you're familiar, the matters for determination, the first one of which is the detail of the point of access. Ma'am, you'll be fully aware of the agreed position on that. So I turn then to the principle of development, which is the sole contested issue. But in the light of the answers of Councillor Wilson, there's no remaining issue on it. The site was designated as safeguarded land in 1997, applying PPG 2. It was designated to meet longer-term development needs, i.e. needs after 2006, which is precisely what it will do. It's agreed that the designation of the site as safeguarded land meant that the authority considered the site to be genuinely capable of development when needed, and an efficient use of land well integrated with existing development and well related to public transport and other existing and planned infrastructure, so promoting sustainable development. Councillor Wilson confirmed that there has been no material change in national policy, rather there has been consistency in approach, and the Council's position has never changed in the intervening years. The site has been designated in subsequent local plans, and the Council considered the development of the site to be capable of delivering sustainable development. Indeed, that's expressly recorded in the Statement of Common Ground on Planning. Well, you're familiar with those points. It's agreed that the emerging plan will cover the period 2021 to 2036. Chorley have resolved to allocate the site in this period. As the plan period has commenced, it follows that the authority endorsed the principle of development on the site now, i.e. from 2021 onwards. The appellant therefore submits that there's no technical or tangible objection to the principle of development, and Councillor Wilson agrees. Indeed, he agreed that there were only 3 restrictions on the development of safeguarded land, which I'll address in turn. Starting with comprehensive development, well, of course, that's fallen away as reason for refusal 3 has been withdrawn. So I turn to the second, the temporal restriction. Well, the Chorley local plan expires in March 2026. It's agreed there must be continuity in the plan-led system. Accordingly, a new plan must be in place a few years before 2026 to allow applications to be made on allocated sites such that delivery can continue from 2026. The LDS states that the Central Lancs local plan will be adopted by November 2023. Councillor Wilson accepted that both the allocation of the site and this outline application seek to determine the principle of development. He agreed that Chorley had resolved, firstly, to adopt a new plan by Q4 2023 and to allocate this site 2021 to 2036. The development of this site would therefore, based on the resolutions of this council, be acceptable to this authority in November or December 2023. If the appeal is successful, Councillor Wilson agreed that consent could be granted in Q1 2022. The delivery schedule is agreed, and it's unlikely that there would be housing completions before Q4 2023, and first completions would be March 2024. In cross-examination, Councillor Wilson conceded that there was no material harm arising out of any timing issue. Indeed, on examination, there's no timing issue at all. Councillor Wilson therefore conceded that there was no timing issue, which is the only rational conclusion to reach. Turning then to the procedural restriction, Councillor Wilson confirmed he had 3 concerns arising out of the procedural restriction and no more, which afforded weight to conflict with BNE 3. Taking them each in turn, decisions taken in isolation. Ma'am, this is Mr. Ponter's point at paragraph 61 if you're interested in cross-referencing back. Whilst the authority have asked for a number of schemes to be called in and the Secretary of State hasn't responded, which possibly suggests the importance of this issue, the authority have not asked for any appeals to be conjoined. Councillor Wilson conceded that should this have happened, there would be no conceivable concern. This option is available to the authority in respect of future applications, where applications could be considered on the same agenda, and in respect of any future appeals. There is no issue. Further or alternatively, Councillor Wilson conceded that once a decision is taken, it becomes a material consideration in the determination of any and all subsequent decisions. He therefore conceded that any cumulative impact can be taken fully into account. Further, he conceded that he did not raise any issue of cumulative impact at all, save his generic concern over release of the Greenbelt, which I addressed below. There is therefore no rational basis for a concern over decision taking in isolation. Next then, harm to the plan-led system. It's common ground there's no arguable harm to any emerging Coppull NDP. There's no such plan. The neighbourhood plan would need to await the adoption of the emerging Lancashire plan, Central Lancs plan, which would set the housing requirement for any designated neighbourhood area. The authority agrees there's no arguable prematurity point in two respects: the approach to establishing future housing requirements or scale of housing, and the distribution of such housing or the location of housing. The framework expressly considers the circumstances in which the plan-making process may be undermined by decisions predetermining the scale, location and phasing of development that is central to an emerging plan. The councillor concedes that his concerns are expressly captured by paragraph 49A, which addresses the scale of housing and the location of housing. The councillor's claim that this is not a prematurity point is therefore flawed. The issues are expressly caught by policy. The councillor accepts that the emerging plan is not at an advanced stage. Framework paragraph 49B is therefore not met. The plan has not yet been submitted for examination, and the conditions of paragraph 50 are not met. Indeed, it's expressly conceded there's no prematurity point. Accordingly, whether or not the scale or location of development is predetermined, there's no arguable conflict with policy at all. Regrettably, the councillor repeatedly, nonetheless, referred to the application as being prematured, echoed again by the Mayor and Sir Lindsay Hoyle, Member of Parliament today, but that position is unarguable. Further or alternatively, there's no substance in the point that the emerging plan would be undermined. Firstly, Councillor Wilson does not allege that the development in isolation would be so substantial as to undermine the plan. This is a proposal for a mere 123 homes, of which only 86 would be market homes, when the emerging plan plans for over 15,000 homes as a minimum. That's 0.79%, and in the absence of a cumulative point, there's no arguable undermining of the plan at all. Secondly, the councillor conceded that the scale of housing development would not, in fact, be predetermined at all. The process to be followed by the HMA LPAs is set out in paragraph 61. Local housing need must be applied unless exceptional circumstances can be demonstrated. This is the approach of the draft plans. Accordingly, the councillor conceded that a decision on this appeal would have no impact on Chorley's future housing requirement at all. Thirdly, this application does not predetermine decisions about the location of new housing development. This site has been specifically and deliberately designated to meet the need for new housing. Save for the requirement for a local plan review, the authority accepts that its development would be sustainable. Indeed, it's agreed that there are a limited number of suitable housing sites in Chorley outside the Green Belt, and such sites are safeguarded land. Well, that's not a surprise. It's a plan-led outcome. It is inevitable that safeguarded land sites will be required in the plan period, as specifically conceived by previous plans. Indeed, the councillor conceded expressly that there was a high probability that safeguarded land would have to be allocated, and currently all, I think we can add in there, Mr. Ponta tells us 145 hectares, all of the safeguarded land sites are proposed to be allocated, and no land is proposed to be designated as safeguarded land. So it's all going to be used. That's the current position. Given the principle of development on this site is agreed, save for the review, it's inevitable that this site will be allocated in the next plan. Councillor Wilson conceded that he had no evidence to explain, given agreement on the principle of development, why the site should not be allocated in the emerging plan, and or why the site might not be allocated. On that agreed basis, there's no conceivable undermining of the plan at all. Indeed, the authorities have already had 2 call for sites exercises. 700 sites have been considered through the SHELAR. Elected members and parish councillors have been consulted, and there's been no objection from Coppull Parish Council, who support the allocation of this site because it's safeguarded. Further, there's been a robust consultation process in the determination of this application and appeal. The scrutiny given to this appeal far outweighs any consideration to be given to an allocation through an EIP process. The result of such consultation and appraisal of the application and the call for sites process is that the principle of development is acceptable and the site should be allocated in the period 2021 to to 2036. Whilst the emerging plan can be afforded limited weight, in the absence of literally any evidence to the contrary, there's no arguable undermining of the emerging plan. It's a baseless assertion, unconstrained by the agreed evidence. Notwithstanding such concessions, Mr. Ponter asserts that the housing requirement has not been fixed, and that's correct. However, there's no evidence at all that there are exceptional circumstances which will reduce the local housing need in figure in Chorley from 579, which is the figure currently being planned to, from 579 to such a level that no safeguarded land will be required. And Mr. Ponter doesn't suggest the contrary. Please see his paragraph 45. That contention is irrational, as this site is acceptable in principle if considered through a review. There's no basis for arguing that the Chorley local housing need should be reduced so as to exclude acceptable sites. That proposition is respectfully absurd. If then, which is not accepted, this is not a prematurity point, there's no rational evidential basis on which it can be concluded that there's any undermining of the emerging plan. This is not a consideration to which any material weight can attach, and there is therefore no merit in what is a de facto moratorium on the development of safeguarded land. In terms of harm to the Greenbelt, there can be no doubt that this concern lies at the heart of the authority's objection and those of local residents. It's equally clear that this site does not lie in the Greenbelt, and there's no direct impact on it at all. The councillor's concern is that the grant of consent would lead to the release of Greenbelt sites through the next plan. That concern is misplaced and has been expressly conceded. It's agreed that the next plan period is 2021 to 2036. The central fact is not referred to anywhere in the council's evidence and explains their misplaced concerns. We are already in the plan period. The councillor agreed that the council must, in essence, through the plan process, resolve its housing requirement, establish its deliverable supply, and if there's a shortfall, consider whether there are exceptional circumstances for the release of Greenbelt. The council conceded that this site already forms part of the authority's deliverable supply to meet identified housing needs in the plan period, and this will not change if consent is granted. The councillor conceded that whatever the base date of the plan, the grant of consent means the difference for plan preparation purposes between the site being an allocation with planning permission in the non-Greenbelt housing supply or an allocation without planning permission in the non-Greenbelt supply. Either way, the councillor conceded quite rightly that the site will count towards the LPA's forward supply. Whether this site has planning permission or not does not affect a judgment on exceptional circumstances and Greenbelt release, because either way it would count in the non-Greenbelt supply. In the light of such concessions, the councillor finally conceded that there was no issue regarding Greenbelt release, and that's the only rational conclusion to reach. Finally, faith in the plan-led system cuts both ways, as appeal decisions recognise. The public, including those who seek a new or affordable home, lose faith in if the planning system repeatedly fails to deliver the homes which people need in the right locations when they need them. Regrettably, those disenfranchised without a home rarely, if ever, make appearances at public inquiries such as this. It follows that the authority's central allegation of land use planning harm has evaporated on examination. There's no remaining concern about the development of the site now, and the principle of development is unanswerably acceptable. I then set out the statutory development plan, the single conflict with BNE 3.6, common ground, the proposal conflicts with BNE 3.6, which is consistent with the framework, and therefore note that it's necessary to understand whether the development plan is up to date and consistent with the framework. And we submit that BNE 3 is out of date for two reasons, which I will address in turn. For both reasons, I only need to win on one of these for the tilted balance to be engaged. So turning then to whether policy BNE 3 is out of date, I rely on the judgment of the Supreme Court in the Richborough Estates case. I rely on the decision of Inspector Hayden, who relies on that decision in the second Pear Tree Lane appeal. You're familiar with those quotes. This is not an issue which the councillor has addressed in his written or oral evidence at all, save for the points I raised in cross-examination, despite it being highly material to the outcome of this appeal. I turn then to the background of the Joint Core Strategy and the Chorley Local Plan. I set out, Mom, and I'm going to take it that you're very familiar with these points at this stage, the RSS, the 2003 household projections, and then the RSS housing requirement, to make the point at paragraph 65 that it's unanswerable that the CBC Chorley housing requirement was heavily constrained by 156 dwellings per annum and almost 3,000 homes over the planned period, and the Central Lancs HMA housing requirement was also heavily constrained. I then note that the Joint Core Strategy was required to be in general conformity with the RS, and the EIP inspector effectively required the authorities to adopt the RS housing requirement without further analysis. So it's agreed that the minimum housing requirement in Policy 4 is based solely on RSS without further analysis. Now, Mom, the LPA submit that because the plan was adopted after the publication of the framework, it significantly boosted the supply. However, it must be noted that the inspector's report is dated the 7th of June 2012 and therefore predated the decisions in Huntston and Gallagher. If I can just highlight some points of this judgment. In Gallagher, it says there were major policy changes in relation to housing supply brought into play by the NPPF, which requires plan makers to focus on fully objectively assess need for housing and to meet that need unless and only to the extent that other policy factors within the framework dictate otherwise. That is a very different exercise from that required pre-NPPF, and the change is clearly intended on occasions to yield different results. Housing data from earlier RSS can be used, but only with extreme caution because of the radical policy change in respect of housing provision of the framework. In one way or another, the inspector was required to assess fully and objectively the housing need in the area. Neither the local plan nor the inspector in that case provided any such full and objective assessment, nor did the RSS. There was no evidence that, as required, they assessed the full and objective housing need before considering constraints. Indeed, the evidence is that they went straight to policy on figures for the region in a conventional planning balance exercise. They then proceeded to carve up that policy on requirement between the various areas within the region. Even as a surrogate, that did not comply with the NPPF requirements properly construed. It's agreed that the EIP inspector found the housing requirement to be sound. However, that conclusion must now be considered in the light of this judgment. The constrained housing requirement for Chorley and Central Lancs is exactly the sort of constrained or carved up housing requirement which cannot be considered even as a proxy to comprise an objective assessment of housing need. And in the light of the relevant case law, it cannot be concluded that the RS housing requirement significantly boosted the supply of housing. The Chorley local plan then simply rolled forward the RS housing requirement. And whilst it may be lawfully permitted to do so, that doesn't mean the adopted figure is thereby up to date or consistent with the framework. And I give you an authority for that proposition. The local plan applies the Joint Core Strategy housing requirement to derive a residual requirement of 6834, and the housing allocations then meet that housing requirement. And so it's therefore agreed unequivocally that the CLP was adopted exclusively on the basis of the RS housing requirement. And it's in this context that Chorley considered safeguarded land. A considerable amount of safeguarded land was allocated, and the residue is now to be allocated. And so the plan has 4 areas: urban, safeguarded, greenbelt, other open countryside. The purpose of the settlement boundaries is to define the interface or boundary between the urban area and safeguarded land or greenbelt. And so they have 2 purposes: to define an area inside of which housing is in principle acceptable to meet the requirements of the regional spatial strategy, and secondly, to define an area outside of which housing is in principle restricted because it's not required at this time to meet the requirements of the RS. Councillor Wilson agreed that BNE 3.6 prevents development because it was not required to meet the housing requirements of the RS. He therefore accepted that the effect of the safeguarded land and greenbelt policies is to confine development to a restricted area planned to meet the constrained housing requirements of RS core strategy. It's unanswerable that the housing requirement is out of date and inconsistent with the minimum local housing need figure in the framework. As the councillor conceded, it is based on demographic evidence and household projections which are significantly out of date, based on a PS3 methodology which embodies constraints and cannot lawfully be used as a proxy for an OAN or the LHN, based on a PPS3 methodology which is significantly different from MPPF 2012 and MPPF 2018, which were intended themselves to be different and to achieve different results, based on a constrained RS figure which manually redistributed housing away from Chorley and central Lancashire, based on an RSS which was revoked almost a decade ago, based on a PPS which has been revoked and replaced by an NPPF which itself has been revoked and replaced, and based on an RS plan period which is time expired. Now, whether a policy is out of date or inconsistent with the framework are separate but related concepts. If a policy is out of date, the tilted balance is engaged. If it's inconsistent, due weight should be given to it depending on its consistency with the framework. Turning then to the first of those issues, in answer to my questions, the councillor agreed that BNE 3.6 is inconsistent with the framework. He conceded that the housing requirement is inconsistent with the local housing need methodology and housing requirement. He accepted the difference is significant. He agreed that the area of safeguarded land is based on an inconsistent housing requirement and therefore conceded that BNE 3.6 is inconsistent with the framework. And he conceded that was the case regardless of whether there's a 5-year supply. The inconsistency is significant. It follows, applying framework paragraph 219, that BNE 3.6 must be afforded significantly reduced weight and only limited weight can attach to it. Turning to the second issue, where the policy BNE 3.6 is out of date, Councillor Wilson did not accept initially that policy BNE 3.6 was out of date, but he did concede. Iceni had concluded that local housing needs should form the basis of the HMA housing requirement and that policy 4 was out of date. The 3 LPAs had concluded expressly that policy 4 was out of date in MOU 2. The LPA's evidence to the PTL 2, the Pear Tree Lane second inquiry, had stated that policy 4 was out of date, and Inspector Hayden had concluded that safeguarded land boundaries had been based on the policy 4 housing requirement, which is now out of date. My note of Mr. Saunders' answers to Mr. Ponter are as follows. If policy 4 is found to be out of date, the point falls away. Well, Ma'am, that is correct, because self-evidently, if it's up to date, it's not out of date. That, Ma'am, is a different point from what is the basis of the 5-year housing land supply calculation. Councillor Wilson's sole point was that there had been a review in October 2017, and it's here that Mr. Ponter at paragraph 88 opens his window before throwing this analysis out of it. But however, even looked at uncritically, the review in October 2017 cannot serve to make the out-of-date housing requirement up to date in the light of the framework in 2018. The review concludes with MOU 1 in October 2017. It significantly predates the framework 2018. It states it will be reviewed every 3 years. It states it will be reviewed when new evidence emerges which renders it out of date. The introduction of an intentionally different standard method is new evidence which renders it out of date. The conclusion of the subsequent review, comprising the housing strategy in MOU 2, concluded that MOU 1 was out of date and local housing needs should be applied. MOU 1 does not, importantly, change any of the above conclusions. The demographic evidence is still out of date. PPS 3 still cannot be a proxy for OAN. PPS 3 and the RS have still been revoked and the RS is still time expired. The review does not, therefore, change the fundamental conclusion that the area of safeguarded land was based on a constrained housing requirement which is agreed to be inconsistent with the up-to-date local housing need in extant national policy. Moreover, the review is relevant to paragraph 74, which refers to a review in the context of the calculation of housing land supply only. The sole consequence of the review relates to that calculation. The operation of policy does not and cannot apply more broadly to a planning judgment on whether policy BNE 3.6 is out of date. That planning judgment is not constrained by policy 74. it follows that the MOU1 review process does not support the conclusion that BNE 3.6 is nonetheless up to date for the purposes of NPPF 2018, paragraph 11D1. Indeed, Councillor Wilson ultimately conceded that regardless of whether there has been a review for the purposes of a 5-year housing land supply calculation, it doesn't change the conclusion that BNE 3 is out of date, and it follows on that agreed basis that the tilted balance is engaged. The conflict with BNE 3.6 must be afforded significantly reduced weight in the application of the tilted balance. The conflict with policy BNE 3.6 must be afforded significantly reduced weight. As policy BNE 3.6 is agreed to be out of date and inconsistent with the framework, the conflict with it can only be afforded limited weight. Turning then to housing land supply. Further or alternatively, the appellant submits the authority do not have a 5-year supply. There are 3 contested issues: whether policy 4 or local housing need derived using the standard method should form the basis of the calculation, oversupply and delivery. There's no scenario in which an oversupply discount is applied to local housing need as it's replaced annually. It's common ground that the authority must therefore win on issues 1 and 2. The outcomes are agreed. Turning to that first issue, the basis of the calculation, I address 2 points, the first of which is not contested. The first is whether it's a matter of judgment. And Ma'am, just on that point, can I ask you to look at Mr. Ponter's closing at paragraph 20, where he agrees at these points, which, because they're agreed, I'll go through as lightly as I can, but I've set them out, Ma'am, because it's not been the case that everyone at every inquiry has accepted this. So, the matter of judgment. The application of policy together with the associated PPG is agreed. It's never been in dispute. It provides that policy 4A should be used as the basis of the calculation because the parties agree there's been a review. It is, however, agreed that this is not the end of the matter. You, Ma'am, are entitled to exercise a planning judgment departing from the policy guidance provided clear reasons are given. Firstly, neither the NPPF nor the PPG represent comprehensive or complete policy guidance which address all the circumstances in which a planning judgment is required. Secondly, it's agreed that neither the PPF nor the PPG preclude changes in circumstances since October 2017 being taken into consideration. On the contrary, it's agreed that the significant changes brought in by the framework and the new standard method are relevant. Thirdly, the planning court have been clear that planning policies can become out of date as a result of events which have happened since adoption, such as a change in national policy, or for some other reason. Decision makers must reach a decision in the light of such changes on whether policies are out of date as a matter of fact and judgment, and I refer to the decision in Blore Homes, and that of course applies to policy 4 as much as anything else. Fourthly, the appellant's submissions are entirely consistent with the judgment of Mr. Justice Dove in Wayne Homes in respect of Inspector Hunt's decision that local housing needs should form the basis of the 5-year supply calculation. In addressing grounds 1 and 3, Ma'am, I may just dwell on these briefly because self-evident reasons. We haven't looked at these judgments in the evidence. The judge held there may be many material changes in the planning circumstances of a local authority's area which would properly render their existing plan policies out of date and in need of whole or partial review. I'm unable to accept Mr. Fraser's submission that it's impermissible to regard the emergence of a local housing need figure, which is greatly reduced from that in an extant development plan policy, as having the potential to amount to a significant change. The question of whether or not any change in circumstances is significant is one which has to be taken on the basis of not only the salient facts of the case, but also other national and local planning policy considerations which may be involved. In short, in my view, the language of the PPG and its proper interpretation did not constrain the inspector and preclude her from reaching the conclusion that she did, namely that the significant difference between the housing requirements in core strategy policy 4A and that generated by the standard method was capable of amounting to a significant change rendering core strategy policy 4A out of date. I give you another reference of paragraph 45. Fifthly, Inspector Dorr relied on this judgment in concluding that there had been a material change in circumstance rendering policy 4A out of date. Sixthly, MOU1 expressly states that it will be reviewed no less than every 3 years and will be reviewed when new evidence emerges, which renders it out of date. Seventhly, the Cardwell Farm Inspector states, it seems to me that there may be justification to revert to local housing need, even if the requirement had been previously reviewed and found not to require updating. Mr. Ponter nonetheless argues that the introduction of the standard method cannot be a reason for departing from policy 4A because framework paragraph 74 and footnote 39 were introduced at the same time. This is not a point in Mr. Councillor Wilson's evidence and misses the point. The significant change is not the introduction of the new policy itself, or per se, rather it's the practical consequences of the new national planning policy which constitute the significant change for this authority. And this is precisely the approach adopted by Inspector Dorr at the second Chainhouse Lane inquiry. I set out the quote, Ma'am, that we previously looked at. It follows that there's no difference between the appellant's and the authority's approach, which is to ask whether policy 4 is out of date, requires a planning judgment taking into account all material considerations. Is then policy 4 out of date as the basis of the 5-year housing land supply calculation? The appellant submits that there has been a significant change in circumstances since October 2017 and relies on 3 significant changes. Firstly, a significant change in methodology. The standard method was introduced because the government wanted to deliver sufficient housing in the right locations. Councillor Wilson agreed that the white paper identified methodological issues, delivery numbers issues and spatial issues with the 2012 methodology, and the intention was to deliver a significantly different methodology in order to address such issues. The standard method has 2 issues, household growth plus affordability. The change in methodology intentionally removed the reference to housing market areas, figures are set at the local level, and removed MPPF Step 2, the consideration of economic forecasts. It's therefore agreed that it's a significantly different methodology to both RSS and PPS3 and MPPF 2012, which underpinned the SHMA 2012. And the change is significant since the review in 2012 because it's intended to yield different results in the amount of distribution of housing. The second factor is a significant reduction in local housing need in Chorley. Ma'am, you know the figures. And I also refer there to framework paragraph 33, which states relevant strategic policies will need updating at least once every 5 years if their applicable local housing need figure has changed significantly. And I then set out the PPG, which makes the point that should take place earlier and that local housing need will be considered to have changed significantly where a plan has been adopted prior to the standard method being implemented on the basis of a number that is significantly below the number generated using the standard method. Those circumstances are engaged here, and yet surely have failed on their analysis to undertake such a review in the 3 years since the framework and the standard method were published, and despite the express requirement for a review in MOU 1. The third change is the distribution of housing. And Ma'am, I marvel at my own word processing skills that I've managed to include a table for the first time in my professional career, and I hope that that makes the point adequately clearly. It's agreed that consistent with the white paper intention, the standard method requires Chorley to deliver the most housing, and that's consistent with the 2003 household projections 573 and the SHMA 2017 519. So whilst the councillor complains that Chorley is over-delivering, this is simply not reflected in the objective assessments of need, which consistently require over 500 dwellings per annum. And again, the councillor conceded that this redistribution is a significant change in circumstances. The councillor therefore does concede that there have been significant changes in circumstances since the 2017 review resulting from this redistribution. And I should read the appellant. Submit that such changes render policy 4 out of date as the basis of the calculation, and that's supported further by the Central Lancs housing study, which the councillor explained was intended to be a review of MOU 1. Its purpose was to advise on the implication of local housing need and whether it should be applied, and to advise on an appropriate distribution of it. The appellant submits they are separate matters and addressed as such by ICENI. At 325, the housing strategy concludes that the minimum local housing need figure of 1,026 should form the basis on which to calculate 5-year supply across the HMA. Ma'am, that conclusion could not have been clearer. It's a conclusion which is emphatically not reliant on any subsequent distribution of the local housing need figure. Having concluded LHN should apply, an appropriate distribution is considered. The housing strategy conclusions are relied upon by all 3 LPAs who signed the MOU, which makes the point that the Council consider that maintaining the use of the housing requirements in Policy 4 is out of date until such time as the review of the plan is complete, and it's not appropriate and has been superseded by the standard method. In reliance on that housing strategy, MOU 2 reaches 2 conclusions: to adopt the standard method to calculate the minimum number of homes in accordance with national policy in replacement of the out-of-date housing requirements in Policy 4, and secondly, the manual carve-up distribution. In August 2020, Inspector Hayden concluded that the contested arguments about the proposed distribution need to be properly tested through the emerging plan process, and the authority have no criticism of that approach or conclusion at this inquiry. It follows from the analysis of the housing strategy endorsed by all 3 authorities in MOU 2 and the second Pear Tree Lane decision that local housing needs should form the basis of the calculation without any manual redistribution. The housing strategy is in itself a change in circumstances since the 2017 review, which provide good reasons for the change in position. It's agreed that MOU 2 is defunct. However, the underlying analysis and rationale is still robust. Preston and South Gribble continue to rely on it, Nick Island continues to rely on it, and Chorley relies on it at this inquiry. It's accepted that it was not argued at the second Pear Tree Lane inquiry that there had been a review. This is because the authority argued Policy 4 was out of date and MOU 2 applied. The councillor argues that the logic of that decision, together with the first Chainhouse Lane High Court decision, is that the manual distribution of MOU 2 cannot apply. Consequently, the LPA refers back to Policy 4 rather than the conclusion of the housing strategy in MOU 2 that Policy 4 is out of date and local housing needs should apply. The councillor takes the authority back 2 steps rather than 1, as the conclusions of the housing strategy are distinct from the conclusions, as the conclusions of the housing strategy on the application of LHN are distinct from the conclusions on distribution. There's no basis for the authority's position. The councillor explained that there has been no transparent consideration of this matter. There's been no report and or no formal decision. To the extent that there have been discussions with professional officers, we don't know the content of any such advice or discussion, but it has apparently resulted in officers failing to give evidence in support of the reason for refusal. The sole explanation for the council's position is therefore contained in the councillor's evidence, and it raises 4 points. Firstly, it's argued that the standard method itself is not an appropriate basis for calculating 5-year supply in Chorley, and the standard method is flawed. This is a frontal attack on the standard method, albeit it doesn't use the Zeitgeist phrase mutant algorithm. Professor, elevating his professional qualifications. Councillor Wilson conceded that the inquiry cannot question the methodology and did not invite a conclusion on this point. It betrays, however, the true feelings of the local politicians. Secondly, it's argued that Chorley is being harmed by its previous good delivery, whilst Preston and South Gribble are being rewarded for their under-delivery. But this is the language of NIMBYs. The proposition that new housing development above minimum housing requirements is harmful, whilst under-delivery is celebrated, is the antithesis of national policy to boost significantly the supply. There is in any event no evidence of any such planning harm. Thirdly, high levels of supply in the early years of the plan have fed into the household projections used in the standard method. This is not a methodological flaw, this is the methodology. This is again an impermissible tack on the methodology and national policy itself. This inquiry, ma'am, must respectfully interpret and apply policy. It's not its role to critique it and invent a new one. Further, it's absurd to seek to argue Policy 4 should apply because of oversupply in 2009 to 14, when this is the central component of the standard method. The central component of the standard method cannot rationally be used as a means of discrediting the same methodology. Fourthly, Councillor Wilson alleges harm to the city deal and relies on the analysis of the housing strategy to suggest an alternative distribution. Mr. Ponter relies on 4 factors in the Cardwell farm. Respectfully, ma'am, such arguments are hopeless. Factor 1, there's no evidence of any adverse impact on the delivery of the Cotton strategic location or the Northwest Preston strategic location at all. There's no suggestion this consent would cause any delay, no objection from any house builder engaged. Preston don't object, on the contrary. Preston specifically argue that local housing needs should be the basis of the 5-year calculation across the HMA. There's no evidence to suggest any site allocation meeting the spatial pattern of the joint core strategy would be adversely affected. Development in Chorley, as opposed to Preston or South Gribble, would not impact on levels of containment inside the HMA because Chorley forms part of the HMA. An out-migration from Preston is being addressed through the Cottam and Northwest Preston strategic locations. As there's no adverse impact to them, there'll be no impact on out-migration. There's no evidence a scheme of 123 homes would impact migration patterns across the HMA. That, respectfully, is fanciful. There's therefore no arguable impact on the city deal aspirations. Precisely the same points were put and emphatically rejected at the second Pear Tree Lane inquiry. There's no arguable basis for reaching a different conclusion at this inquiry. Reliance on the distribution arguments in the housing strategy, this is Mr. Ponter's paragraph 44, is perverse. The substance of the argument was expressly put at the second Pear Tree Lane inquiry by the author of the housing strategy, who was intimately familiar with his own report. The inspector concluded such arguments did not undermine the use of local housing need, but should be considered through an EIP. Now that MOU2 is defunct, the authority is simply seeking to resurrect precisely the same arguments, but under the aegis of the housing strategy. There's no evidential basis for reaching a different conclusion on the same distribution evidence. Ma'am, can I just add an 8th point relating to risk to safeguarded land? Mr. Ponter, paragraph 62(5). There's no arguable risk to safeguarded land if, as here, it is otherwise acceptable in principle. Finally, ma'am, some reliance is placed on the Cardwell farm decision, but the appellant, like others such as Preston, has a concern about it. The inspector accepts that MOU1 could be reviewed, but then invents a requirement unknown to law or policy that the decision to depart from the findings of a review undertaken in the last 5 years would need to be supported by a robust process. Having invented such a requirement, it is then used as the basis to revert back to the out-of-date policy 4. In this case, it's agreed that a planning judgment must be exercised. There's no requirement that such a judgment can only be exercised after a robust process. Accordingly, this decision needs to be treated with caution. Further, it was expressly considered in the Chainhouse Lane decision and rejected, and we submit that greater weight should attach to that decision, and Preston and South Gribble agree. Further, Chorley recognised that their approach would lead to an inconsistency across the HMA. It's airily dismissed by the Cardwell Farm Inspector and this authority. It is, however, a significant matter. These 3 authorities have produced a single joint core strategy and intend to do so again. The joint core strategy is clear that the combined area functions as one integrated local economy and travel to work area. It's a single HMA with nearly 80% of house moves taking place within it. The joint core strategy therefore addresses the similar issues facing central Lancashire in a collaborative way, and so better plans for the future of the area. An inconsistent approach is the antithesis of the joint core strategy approach. Further, it would lead to housing delivery dropping off a cliff, as the authorities plan for variously 190, 250 and 104 dwellings per annum, which is less than half the minimum local housing need requirement. It cannot be countenanced. There is therefore a 2.4 to 2.6 year supply. Turning to oversupply, the authority have delivered 6,316 units. There's a residual requirement of 518 against the minimum requirement of 6834. 518 over 5 years results in an annual requirement of 104, which is then the basis of the calculation. At a time when their local housing need is 537, Chorley's planning alchemy has reduced this to a mere 20%. It's common ground there's an absence of policy or guidance on this approach, and it follows that this approach does not amount to an error of law, as it doesn't amount to a misinterpretation of policy, but it's in that context that the authority's planning judgment must be tested, and we submit that the approach is deeply flawed for a number of reasons. Firstly, this isn't an oversupply, it's simply delivery above a minimum, and the authority failed to identify any adverse land use planning impacts which flow from any such oversupply. Secondly, it's based on the premise that Chorley is harmed by good housing delivery, while South Gribble and Preston are rewarded for poor delivery. I've addressed that point. Thirdly, it's inconsistent with an objective interpretation and application of policy 4A. Ma'am, you have those points well in mind. Can I just ask you to add after point 1, Mr. Ponter's paragraph 74. This doesn't mean that it's a steady rate. It can fluctuate. It must simply fluctuate above a minimum level. And so, ma'am, at 137, Mr. Ponter is wrong to assert that policy 4 is concerned solely or evenly principally with delivery across the plan period. It's concerned with both annual delivery, continuing forward supply, and delivery across the plan period. It's both matters, and that's abundantly plain from 4A and 4C together. Policy 4 requires Chorley to set and apply a minimum requirement of 417. This is not, on the wording, an annual average, it's a minimum annual requirement. Fourthly, it's inconsistent with an objective interpretation and application of 4C, ma'am. You know what that says. The authority's approach is not continuous, it's reducing over time and will reach 0 before the end of the plan period. It's not forward-looking, as it looks back to delivery at the start of the plan period. It's not based at the start of the annual monitoring period because it looks back across it. Policy 4A and C must be read together, requiring a continuous 5-year supply based on an annual minimum requirement. In contrast, the authority's approach will fail totally to address the need for affordable housing, and 30% of 104 at best is nothing short of a conscious decision to refuse to meet objectively assessed housing need, contrary to Policy 7, Strategic Objectives 5 and 8, and the Council's corporate priorities. The trajectory is not part of the policy. It's not relevant to an interpretation of Policy 4 and cannot override the clear words of it. The trajectory is silent on the 5-year supply. It sets out lower levels of delivery in the latter stages of the plan, but it's silent on whether that should translate into a sharp reduction in the annual housing requirement. For the purposes of the 5-year supply, the trajectory is evidence from 2015 demonstrating that the minimum housing requirement can be met such that the plan can be found sound. It's not seeking to curtail housing development. There's no policy support for that approach at all. Fifthly, ma'am, the approach is inconsistent with NPPF. Ma'am, you have those points well in mind. In terms of Mr. Ponter's paragraph 69, ma'am, I say in paragraph 141, this of course may apply to any and all such local authorities who apply this approach, but that doesn't diminish its force nor preclude the exercise of a planning judgment on a case-by-case basis, taking all of these factors into account. Rather, it's a factor which suggests, without conclusively determining, that the authority's judgment is a poor one. Sixthly, the approach is inconsistent with HDT, because if completions fall below 95%, an action plan is required. The HDT is separate but complementary to the requirement for a 5-year supply. Failure to meet either can result in the application of the tilted balance. The HDT therefore ensures consistent, strong levels of housing delivery. The authority's approach would deliver approximately 20% of its HDT, well below 75% at which the tilted balance is engaged, which would then require an action plan to remedy the shortfall. This must indicate that the approach is flawed and inconsistent with the framework. Ma'am, in terms of Mr. Ponter's paragraph 76, the HDT looks back only over the last 3 years. It tells you nothing about the delivery of the planned period housing requirement, he says. But, Mum, that's precisely the point. It's concerned with continuing forward supply. And as to the second point, which is, well, not a single inspector who's grappled with it has found on this point, I think that there's an absence of a decision rather than any decision one way or the other, so that doesn't take you any further. Seventhly, there's no support in PPG for this approach. Eighthly, it's agreed that there's a number of decisions which pull in different directions, and in one of the more obvious and self-serving submissions, I say that we submit that the reasoning in the decisions dismissing this approach contain the reasoning which is the more compelling. By contrast, the councillor raises a single point that the same logic should apply to oversupply as to undersupply. The proposition is risible. The same logic does not apply, as the councillor conceded, because there is a clear conceptual difference. Undersupply must be remedied to meet the minimum requirement of government policy to have a 5-year supply. Delivery over a minimum does not require remedying, at least not in the absence of some land use harm which flows from genuine oversupply, such as housing market failure. Whilst the courts may decline to rule that oversupply is unlawful in the absence of policy, that does not mean that there is any merit in this approach. I then turn then briefly to the planning balance, sustainable development, social role, need for market housing, so significant weight in the absence of a 5-year supply. But even if there is a 5-year supply, the local housing need figure is still a material consideration. That's agreed at Mr. Ponter's paragraph 40. We say it's in any event a material consideration of significant weight. And so therefore, whether or not there's a 5-year supply, significant weight must attach to the need for housing when the authority has a forward supply of 1377 to 1504 and an up-to-date LHN of 537. Turning to affordability and the need for affordable housing. The core strategy demonstrates an annual shortfall of 132 affordable homes for rent. Applying the development plan, this would require 132 affordable homes in total, requiring 620 market homes. Further, there's recently been exponential growth. There are more than 2,000 households on the housing register, of which 44% have a very acute need. The position is characterised as very severe. A requirement of 104 dwellings per annum is wholly inadequate and will fail to deliver an adequate level of affordable housing. Affordable housing delivery is declining at the same time as newly arising needs are continuing to grow, yet those in acute need, whether in Chorley or Coppull, are being told to wait without reason. Further, there's an issue with affordability. It follows that very significant weight attaches from the delivery of affordable homes. In terms of sustainable location, we know Coppull's a sustainable settlement and the appeal site's an accessible site adjacent to it. There's no arguable highways impact, which is severe. There are economic benefits to which we attach moderate weight. Can I ask you to add at the end of 161? There is no evidence of any infrastructure constraint save for education. I turn then to the common ground on the environmental role, the improvements comprising open space provision and biodiversity net gain, and an acceptance that there'll be an adverse landscape and visual impact, but no more than the inevitable impact on a greenfield site to which development is directed. Accordingly, the sole impact derives from policy conflict with policy BNE 3.6 as the site is currently safeguarded land. For the reasons given above, the safeguarded land policy must be given limited weight. Further, there's no tangible land use planning harm which flows from the breach. BNE 3 is a timing provision and there's no adverse impact as a result of consent being granted on a draft allocation and a plan set to be adopted in 2 years' time. There's no prematurity point and no arguable prejudice to the plan process. We therefore submit that on the application of the tilted balance, there's no adverse impacts which significantly and demonstrably outweigh the benefits. On the contrary, the benefits significantly and demonstrably outweigh any conflict with policy BNE 3.6. And on the flat balance, material considerations significantly outweigh the conflict with the development plan. Finally, briefly on the education contribution, it doesn't go anywhere because of the section 106. But it is just worth reflecting at 168 that the SIL regs and paragraph 57 place a legal and evidential burden on this local authority to to demonstrate that the secondary school contribution is necessary and directly related to this development. The legal policy test is not passed because there is provision for a subsequent clawback. The authority has not provided any material evidence to this inquiry. It relies on the LCC evidence. It's agreed that LCC has a statutory duty to school Lancashire pupils, but that's not a forensic get-out-of-jail-free card. The appellant, based on specialist advice, has raised the issue of Wigan pupils in Southland School. The essence of the point is that development pupils will displace Wigan pupils and the LEA will discharge its statutory duty. The detail is not repeated. The LEA accept there are Wigan pupils in LCC schools and account for them in their future projections. There's no doubt that Wigan pupils are projected to attend Lancashire schools. However, Lancashire have failed, whether for good reason or not, and we say there's no reason, to provide the current numbers, the projected numbers, the basis on which such pupils have passed the admissibility criteria. The appellant contends that Wigan pupil will be displaced from Southlands by the preferred Lancashire pupils at the development, consistent with the Malpass decision. Further, there is a total absence of evidence from Wigan, who have failed without explanation to provide any evidence on current and projected pupil numbers or future capacity. The appellant, and Ma'am, I remind you, self-evidently, we're not an LEA, has done the best it can with partial and incomplete evidence, which Lancashire County Council and Wigan could or should have. In that context, Lancashire County Council have skillfully reversed the legal, policy, evidential burden onto the appellant. Ma'am, we don't have to prove anything. The LPA must demonstrate a contribution is necessary, and in the absence of robust, complete, proportionate evidence, they have failed to discharge the legal policy requirement. It's therefore our case that planning permission should be granted subject to conditions under Section 106, unless there's anything further, Ma'am, those are my submission.
Okay, thank you very much, Mr. Cannock. That was a good canter through. Right. Okay, then. Right, next thing on the agenda then, application for costs. I'll just ask if any party wishes to make an application. So I'll go to you first, Mr. Cannock.
Not from our side, Ma'am, thank you.
Mr. Ponter? No, good. Thank you very much. Site visit, as you know, I intend to go off and do my site visit after we close today. Do that on an unaccompanied basis. Yeah, is that okay? Yeah, no issues?
Yes, Ma'am.
Right,
By which I
good.
mean no, Ma'am. No issues.
I know what you meant. Yeah, so as you know, I should do that shortly. So is there anything about the party before I close?
Playing pitches.
Playing pictures.
You wanted to know, I think, which.
Yeah, I remember now, yes.
Shall I tell you?
Go on, tell me.
Jubilee playing pitches, Coppull. Gillette playing fields, Chorley. Buckshaw AGP, which I would guess stands for Artificial Grass Pitch, Buckshaw Village. Astley Park playing pitches, Chorley, are the likely recipients. And confirmation from the open space officer that in respect of children and young people's provision, it's a qualitative point as opposed to a quantitative point. That was it.
That was it, yes. Yes, all right, yes, reminded me. Okay, right, lovely, I've got a note of that. Thank you very much. Right, all that leaves me to do really then is to thank all parties for their contributions over the last 4 days or so. In particular, I want to thank the council for their hospitality. It has been very, very helpful to us to be able to continue this as a face-to-face event rather than virtually. It's certainly the first one I've done face-to-face for about 18 months or so. But it's quite refreshing to be able to do that again. So thank you for your hospitality. In particular, I want to thank all the council staff that has helped here, not just the planning staff. Certainly with the YouTube channel and the ability to live stream the event, and also for your assistance in setting up the dedicated web page on the website with all our core documents. So thank you to all of the council staff that has helped us in that regard.
And we would certainly echo those thanks, Ma'am.
Thank you. Right, so that's all that's really left for me to do now then, is to formally close this inquiry and wish you all a good and safe journey home.